So, Rachel, Tom, as I've done with others, in the beginning, I just confirm that, you understand that we're recording this. And that recording may be available, if someone from the public, requests it. And that it's, for my reference and, having the ability to be able to reference the video while preparing our report. So, could you just confirm that your understanding is that we're videotaping this and that we have your permission to do so?
Yeah, in fact, we're all in favor of transparency for all of the videos to all become public.
Okay.
That's been our posture from the beginning with the BAA.
Okay. So, thank you for agreeing to be interviewed today. I want to ask you a little bit about your background. So, how long have you been a resident of the town of Enfield?
Born and raised there, so it's 76 years.
Okay. And I know a little bit about your background. Where did you graduate from high school?
Enfield High School.
And then I think my recollection was you said you went to the second best Catholic college in Massachusetts.
No, your recollection's faulty on that, but it is Holy Cross.
Okay. And so you went to Holy Cross. And then after Holy Cross, where did you, and my understanding is you went to law school, is that correct?
UConn Law School.
And what year did you graduate from Holy Cross?
68.
What year did you graduate from UConn Law?
73.
And did you do something in between?
Yes.
And what was that?
Well, in 68, as soon as I got out of school, my wife and I married. And then I played football for 2 years in the Atlantic Coast League. First for the New York Jets farm team at Bridgeport. Then that was 68 to 69. And they got me a job in New York City working for an insurance firm on, might have been Madison Avenue, I'm not sure. Then the following year, I got traded to the Patriot farm team in Quincy, played for the Quincy Giants in the Atlantic Coast League. And during that period in the off season, I taught school at Tech High in Springfield. That was 68 to 69, and then 69 to 70. I got a job at the prison in summers, part-time, and then became a parole officer for the state of Connecticut. And once I became a parole officer for the state of Connecticut, I applied to law school and got accepted at UConn Law in starting in September of 70. And so at that stage, we had one child, and I decided to forego any football career and then concentrated on law school. I went full-time while I was working full-time in the parole department. And then in my last year of law school, I became a criminal justice planner for the Naugatuck Regional Planning Agency in Waterbury and the 13 surrounding communities. So that brings you to 1973 when I graduated from law school.
And then where was your first job out of law school?
Director of the 13th Circuit Court in Windsor Criminal Justice Coordinating Committee, coordinating the police departments and that participated with the 13th Circuit Court, which would have been Enfield, East Windsor, Granby, Windsor Locks, Windsor, maybe part Bloomfield also.
We don't have circuit courts anymore, right?
No, they actually moved to Enfield afterwards.
Okay.
Yeah.
And then after that position, what did you do next in your career?
Well, I taught school at Holyoke Community College. Actually, that started kind of overlapped when I got out of law school. Part-time, I taught criminology and criminal justice and corrections, and I believe juvenile delinquency on a part-time basis for a couple of years, and then started my own law practice. That would have been October 23rd of 1973, while I was director of the 13th Circuit Court Criminal Justice Coordinating Committee, and then was in that law practice by myself until January 1st, 1978, when my brother and I got together. My brother Russell had become a lawyer, and then later that year we moved to Enfield at 92 High Street, And we've been there ever since.
And you're still in the same firm today, is that correct?
Yes. Mhm.
And what's the name of the firm?
Tyler and Tyler.
And aside from, we've talked about your professional career. Do you have any experience with farming?
Yes.
And what is your experience of farming?
Well, my parents and ancestors were potato farmers. They came over from Ireland in the maybe 1850s or so. And my first recollection of working on a farm was when I was 3 or 4 years old. We have potato farms in East Windsor, in the Windsorville section. My grandmother's name on my father's side is Coleman, and so Coleman's had a lot of the potato farms. And my dad also ran a store back in Broadbrook. After working on the potato farm, then as a kid growing up, I got a job with Hathaway Steen working on tobacco, and then worked on some tobacco farms through high school. And then after the experience that I just described to you, becoming a lawyer in '74, I bought, along with my father-in-law, who was also a farmer, bought a tobacco farm in East Windsor on Broadbrook Road, where we grew tobacco, and then bought a second farm in East Windsor in '75, where it started off with corn, and then we turned it into tobacco because we tested the soil and it was more conducive for tobacco. The farm on Broadbrook Road, we actually held until I think it's 2 years, or maybe 2 or 3 years ago. My wife and I sold it. So that was from '74 on. And then the one in '75 is the only farm we still have left in East Windsor, on Depot Street, East Road, Reservoir Avenue. And it's 13 acres left, which is basically a tobacco farm. The other farming I did was 3 farms in Enfield, 2 on Mullen Road that came from my wife's family to her, and then 1 on Post Office Road that she got from her father. And then there were 2 other farms that we ran in Suffield, Mapleton Avenue and Mountain Road. All of the farms that I just mentioned to you, for exception of Post Office Road, grew something, and they grew either tobacco or vegetables. It might be cucumbers, pumpkins, corn, squash, things of that nature. I also was a member of the Farm Bureau, Connecticut Farm Bureau, from '74 until a couple of years ago, when my membership expired because they went kind of high tech and only notified you not by mail anymore, but by internet. And so I missed that. So I'm no longer a member of the Farm Bureau, but I was since like 1974 to 2019, 2020. And I'm up on a lot of the 490 stuff because we applied for and got 490 classification in each of the towns that I mentioned to you that we own farms. The only farm, again, we have left, 1 in East Windsor. We're downsizing.
Okay. That's helpful background. Have you, other than being elected to the Board of Assessment Appeals, have you previously been elected or appointed to any positions with the town?
Well, I did. I was the legal counsel for the North Central District Health Department back when they formed 1974. I actually incorporated for them a guy named Nick Lavdekay, which was the first director. And the North Central District Health Department at that time was comprised of Enfield, Windsor Locks. I'm not sure about East Windsor. I remember Ellington. And then, so I did that for until 1990, through 1990. And then I got off it and went on to other things and gave somebody else a chance. The other thing was the Enfield Housing Authority. I was legal counsel for the Enfield Housing Authority. I'm going to say from maybe 78 through 84, 86, something like that. Those are the only 2 I can recall.
What I was, with regard to the town of Enfield, were there any other positions? Did you serve on any boards or commissions?
Well, for the police department, I remember that they had board that would interview prospective officers, and that was one of the 3 members on that board. That was just appointed by the chief of police.
So subcommittee, really.
I don't know if it's a subcommittee or what. I mean, it's just, it was through the police department.
You weren't a member of the police commission, for example.
They didn't have, well, you know what, they had a police commission before I was a lawyer, but when I was a lawyer, there's no longer a police commission. This is just a board that they put it, the police chief, Walter Scour, put me on.
My understanding was that were you a party chair at some point?
Oh, okay, but that's not appointed by the town. Yeah, it's the
You're right.
Democratic Party.
Yes.
Yes, let's see. I was a member of the town committee and then ran for chair. I'm trying to think of exactly when. This would have probably been end of 86, beginning of 1987 through 1990. I was the chairman of the Enfield Democratic Town Committee.
Okay. Going back just to elected or appointed positions with the town. How long have you been on the Board of Assessment Appeals?
Well, I was on initially for about 8 or 10 years. And then I got off when Lori Lungy got on. So I don't remember when she got on, but it's probably 5 years ago that I had gotten off because I felt that my health wasn't so hot. So I got off and I remember Lori got on and then I got back on again in January 1st of 2022.
Okay, so it's fair to say you were on for approximately 8 to 10 years.
Yeah.
And then you got off
for probably 3 or 4 years.
Okay, for a period of 3 or 4 years, and then you got back on in 22. Is that correct?
Right.
And so you were was it appointed or elected?
That's appointed.
So you were appointed by the
Town council.
Okay, by the town council, and so you were in place to be able to adjudicate the Board of Assessment Appeals hearings, which took place in the spring of 2020, based on the 21 grand list. Is that correct?
2022, not 2020.
I meant to say 2020.
Yeah,
Thank
yeah,
you for correcting
2020.
me.
Everything happened in 2022. I was there for.
Okay. In your role as an attorney, you mentioned various institutions or organizations which you represented that are quasi public or public. Have you ever served as the town attorney?
No,
Aside from Enfield, have you ever served as town attorney anywhere else?
no.
Have you ever represented property owners in municipal tax appeals?
My father once in East Windsor, where they were, he thought they were grossly excessive on a farm that he owned. As I mentioned to you before, potato farming. And after potato farming went down, then there was a dilapidated building on the property. And so I did represent him before the Board of Tax Appeals or Board of Assessment Appeals, whatever they called it. This would have been in the 70s. Okay. In East Windsor, and they did reduce his taxes, but never took an appeal to Superior Court, if that's what you're getting at. And actually in Enfield, I don't recall ever appearing before Board of Assessment Appeals before I got on, after I got off, and before I got back on again. No.
Okay. My father was my most difficult client over the years.
Yeah.
Let's see here. During your years of representation, have you done any work with the have you handled any appeals or other matters involving the Freedom of Information Commission?
I have to think about that because there may have been some with when I was legal counsel for the North Central Health District, and I do recall one where the director was delivering files to me of somebody that they had the the board at the one of the employees for the health district had screwed up on. And so he's given me the file because they felt that if they give you the file, then it's privileged and it's not subject to freedom of information. And I remember explaining to him that, I'm the best thing you can do is be open with the public. And I refused to accept the file. I then got the freedom of information. I think the person's name was Mitch something, to come to Enfield and start explaining to our guys about freedom of information. And I remember saying, everybody screws up, and that's one thing. But if you're going to start hiding stuff, then that turns the corner in terms of what's prohibited by freedom of information in the law. So I don't recall any others that I had with freedom of information on North Central Health District. There might have been one or two with the Housing Authority also, but it never got to a full hearing because we always resolved it basically in favor of transparency.
I want to talk about your role on the Board of Assessment Appeals. What do you believe the role is of the Board of Assessment Appeals?
Well, to listen to grievances by taxpayers in terms of what where they may feel their taxes are excessive, grossly excessive, and we try to give them a fair hearing and an opportunity to explain their position. At the same time, we take into account what the town's position is, and we try to resolve things fairly and equitably for all parties concerned, including trying to maintain the same standard that we use for everybody across the board. When I say everybody, I mean residential or commercial or the farmers or the daycare providers or so on. So they all have kind of different focuses from where they're coming. But part of the thing we do, I think, is to provide a release for people so that they feel as though they're treated with dignity, respect, and fairly, and not abused.
That's important. So did you attend over the years serving on the Board of Assessment Appeals? Did you attend any training or educational seminars prior to or during your time on the Board of Assessment Appeals?
No.
Over the years, has anybody from the town offered you an opportunity to attend any training or seminars?
I just got offered one a couple of weeks ago, but I was recovering from surgery and unable to go. Well, I should let you know too, though, that even though I didn't go to these things, I would get the books that they had. I was very interested in getting them and actually brought a couple with me today.
I was going to ask you, that's my next question. So the BAA handbook. So I see you've got some notes on it and you marked it up. So have you had an opportunity in the past to review the Board of Assessment Appeals handbook that is promulgated by the Connecticut Assessors Association?
This is it.
Okay, so the answer is yes then, right?
Yes.
And when was the first time you've had an opportunity to review that document?
Well, when we were doing our appeals last year.
All right. So was 2022 the first time you had a chance to review the handbook?
Most recently, I would have looked at it during my last time before I even went on the board. I would have looked at whatever they had available. This one is the revised edition of 2017. So
it's a pretty good document. I've done.
Excellent.
I provide training on a regular basis to boards of assessment appeals throughout the state, mostly in Southern Connecticut, and I find it as a pretty good document. Although I do an outline supplementing it, and when I walk through, my briefing is usually about an hour and a half, and I generally will refer to various parts of the handbook because I think it is pretty good.
As an aside, I did I would bring it to all of our meetings because you'd be amazed how many times you want to check and look back to something. I also would bring our Farm Bureau from 2010 and 2015. So I got the one from 2010 with me today. So, but
I have the updated one. Yeah,
Yeah.
that's the book that's.
I do have it also, but it's in my office, I think, so. I didn't-
Yeah, but I have a copy here. I
Yeah.
mean, and that's the
Yeah.
book that's produced by the
Yeah.
Farm Bureau,
Yes.
correct?
Mhm.
Do you have any background knowledge or training regarding the valuation of real or personal property?
Yes.
And what is that?
Well, besides working heavily in a firm that does a lot of real estate, probate, and those matters, I also was hired by, or I shouldn't say hired, retained by some state and federal agencies with regard to real estate related investigations.
And what were those investigations?
Well, in the 70s, I was a chairman of a state grand jury. That's before they got rid of those. Then in the 80s, there was a one-man grand jury on municipal corruption, where I was an expert for them, and that actually involved Enfield. And then in the 90s, since then, by the Department of Justice, the FBI, for some of their investigations. And most recently, well, I brought with me and they gave me an award.
You brought the award?
No, I left the award home, but I brought the letter from the FBI on the investigation. It was a 4-year investigation for what they call a Shoreline Capital Mortgage Flipping investigation. And so I can give you this, you can put it with your other stuff too.
Sure. Is this my copy?
That's your copy, yeah.
Thank you. So with regard to valuing real estate, are you from, do you have any experience in valuing or considering valuations related to commercial property?
None that I could think of.
Okay. So are you familiar with the the different approaches for valuing commercial property?
Well, Lori's really the expert on that in our panel. I mean, you go by income approach. I think they call it cost approach. And to determine fair market value. And then the other approach is what other properties are going for, like situated. So
Sales
those are
comparison.
based,
Yeah, those are the three big ones.
yeah, but they so basically have somewhat of a working, knowledge of it. But and in our stuff here, I would rely on Lori because of her extensive background and expertise in that area.
Okay. So is it fair to say that you're generally aware of the various approaches to value, which would be the income capitalization approach, the sales comparison approach, and the cost approach, but that you don't have experience in valuing real estate under those approaches?
I wouldn't say I'm not an expert in any of those.
Okay.
But the one I'm probably most familiar with would be the sales, because that's what we deal with as lawyers, is more sales rather than the other approaches.
And
That's what I do.
Yeah, and realistically, on a Board of
Yeah.
Assessment Appeals, I mean,
Yeah.
I think the best approach to consider is the sales comparison approach, because
Yeah.
what you have in front of you is the actual sales.
Right.
Personally, I'll just give you my 2 cents on this. The towns that I represent, I recommend to their Boards of Assessment Appeals that they do not hear, which you have the right to do under Connecticut law.
Yeah. Anything over $1 million.
Yeah, I think it's an assessment, commercial
Yeah.
prop, and it's for commercial properties. And my recommendation is to not hear those appeals, because I think you're wasting the property owner's time, their professionals' time. And furthermore, I don't think you could ever do your proper due diligence, because you don't know what you're missing. You don't know what they may want to show you certain income and expenses, but hide other stuff. And It's just, in my opinion, not good practice for
Yeah,
BAs.
I think that the time I was on before this time, I can't remember any over $1 million that we did here. We just automatically deferred and then they went to court on it. This time, I believe we took up a few, but I don't remember exactly which ones they were. But they were more the ones that Lori was comfortable, that she had enough information on to try and do something with. And of course, when you don't hear them and they're over $1 million, they automatically go to court. If you do hear them and they're over $1 million and you're comfortable with making a decision on it as a group, then I don't think any of those that we made a decision on went to court. I think they were relatively pleased, but Lori would know.
Yeah,
on that better than me.
and they don't automatically
Yeah.
go to court, the ones you don't hear, but the property owner certainly has a right to
Yeah.
appeal it under Connecticut
Right.
General Statute 12117A, within 2 months of the date of your issuance of your decision. So, we talked about your background in farming,
Mhm.
your understanding of farms. Do you have any particular training regarding PA 490 exemptions or assessments?
Well, I did go to some Farm Bureau seminars that they had. So I'm trying to think of when the last one was. I know I went back probably when they had this book coming out in 2010, because that was the first time I think it was available to us as Farm Bureau members. And I'm sure I went to a couple other ones, maybe ones on wetlands that they had, but I don't have a recollection right now of exactly when or where. So it's probably about 10 years ago or more.
With regard to the other BA members, you've mentioned today, did you have any, prior to them being on the board, did you have any, did you know who they were? Did you have any relationships with any of them prior to going on?
Well, I know who they are. Yeah, and I have a relationship with Donna, to take care of Donna first. I know her next door neighbors were in a serious car accident with Zukowski, and they were hit by a drunk driver and broke their legs. And they're both hospitalized. And when I went over, this is back in maybe late 70s, when I went over to the house, Donna was the kid who was babysitting their kids. That's the first occasion I have to meet with her. Subsequent to that, I had brain surgery in '82, and I believe it was either her mother or father. One of them was very sick. I think it was her father. And I met her again at that time in '82, and my operation obviously was successful. I'm still here. I think one of her parents passed away shortly thereafter, but I believe I was during recovery in there for a few days and had a relationship with father, mother. I can't remember which now, and so knew Donna from there. Then the next time I would have had occasion with Donna was actually on the Board of Assessment Appeals the first time when I was asked to go on the board because the board was not treating its the taxpayers or people who appealed with some dignity and respect, and asked me if I could bring some more decorum to it and have it be a quasi judicial type thing. And so I was put on. At that time, the other two were Republicans, so I'm the Democrat. And then when one of the other appointments came up, one of the people got off that Donna came on. And so that's when I met her again, but I can't tell you the exact date. Maybe it's 10 years ago or so.
I don't need to know the exact.
Yeah,
date.
and then I was elected chairman of it for a few terms, maybe 2 or 3 terms. And then I got off, and I believe Donna then was elected chair. So, and then when the Republicans lost this last time, the Democrats took over, then you have more Democrat control, and 2 seats for the Democrats instead of just 1. And then I was elected chairman again, first time back on here in 2022.
And Lori, did you know her prior to?
Yeah, Lori, let's see, going back to Lori, represented her father in terms of a building corporation and building houses in the mid to late eighties. And Lori at the time worked in the office, and as we're putting together closings, she was the contact person for closings. I'm thinking it's maybe a 40-lot subdivision or something of that nature. So, we had the same documents you would need for every real estate closing on a new house. And Lori was the contact person through that. And then that ended, and probably didn't see her again until early 2000s, when she was having some issues with inland wetlands. And so I was her attorney. When I say her and her husband's attorney with regard to an inland wetlands issues in Enfield that was already in litigation. And then we resolved the litigation to everybody's satisfaction. And that was the end of that. And then later on, with my wife's property, well, actually my father-in-law's property on Post Office Road, then Lori was an appraiser working for Farm East Credit at the time, and she was just learning how to be an appraiser. In fact, the guy who was training her is one of the guys that's on here, George Amelia, here being the Farm Bureau's public acting thing. George Amelia, senior branch appraiser, Farm Credit East. So he was training her, and George is the appraiser we used with regard to stuff we had to do on Post Office Road. He's also on the Inland Wetlands Commission and is a soil scientist. So he was great training for her. But I digress. So then when the property was ready to be sold, Lori was the buyer for this 7-lot subdivision. Unfortunately, the town went in and put a water course on the property and then destroyed the marketability of that property for a few years. So Lori was the buyer that then we lost her as a bona fide buyer. We did sue and won the case. There's a stipulated judgment on it, which I have a copy of if you care. I'll tell you where it may be important is that
I'm curious to know how they put a water course on the property.
well, they just because the across the street and up a little bit, upland was a piece of property that some politically connected people owned. So they just through the town, and it was covered with water. So through the town, they drained the water. So they drained it on property next door that was owned by a church that the church not there. It's just vacant property. So they didn't know what happened. And it went on property owned by a lady named Nitch, and it ruined her horse farm. Then it came around to Post Office Road, and there was a culvert there leading to my father-in-law's property on the opposite side. The problem they had is the culvert on my father-in-law's side was a little higher than the other side, so the water was stopping on Post Office Road side and backing up. So the town sent its couple of its public works guys down with a backhoe bucket loader. They dug a what they called a plunge pond, so it would be lower, so the water would then flow onto my father-in-law's property, and they used a dry drainage ditch. This used to be corn, a dry drainage ditch to then flow across the property, and it destroyed that lot, and it affected 2 other lots. When we didn't know what they were doing, but then the beavers came, and when the beavers came, they put a beaver dam there, and then my wife was friends with Kathy Eldegill and into animals in terms of their welfare. She's not a nut, but she donates to physicians, something or other, donates to PETA, and is concerned about Friends of Animals is one of their friends. So what we found is it was reported to us that the town had killed a beaver, and so we then investigated it and found exactly what I just told you, at which point in time we asked the town to cease and desist what it's doing, restore the property to its uses, and then we could move on. They didn't do it. So we sued in two courts. Kathy Eldegill sued on the animal rights issues because they never went to the state either to do anything with the beaver dam. That was in Rockville. And the other one we sued in Enfield, in Hartford, Levy and Droney. And that's the one where we got the stipulated judgment on that says that the town did a bad thing, and they agreed that what they did was a nuisance, and they because they had destroyed the marketability or made our lots unbuildable from 2006 to 2016, we had paid $99,000 in real estate taxes at the time. They had to reimburse us the $99,000 that we had paid. That was part of the stipulated judgment. I did bring copies, and I'd be happy to give it to you.
Sure. We can. Interesting.
This is stipulated judgment. It refers, I think I highlighted this one, I hope. Yeah, good. The only parts I highlighted are things where it pertains to like the where they had to pay the money and stuff. But you're welcome to read the whole
Yeah,
thing.
I could put it in the record. Interesting.
Well, it's just from my frame of reference in terms of if the marketability is destroyed on somebody's land by the town in an egregious manner, then I believe that that has zero value. But the town is the one that's responsible for it. And part of my frame of reference is this particular case that I was thinking of in the back of my head. I think I gave you one over there.
So have you represented Lori? So just so I want to make sure I understand your response. So with regard to whether you knew Lori and Donna, you explained how you knew Donna, and with regard to Lori, it's my understanding that have you represented her on or off over the years?
Only on the inlands wetlands thing, and I'm a family friend.
Okay.
So, but on anything she had to do with the town, other than the inlands wetlands I described to you from maybe 20 years ago, no, I didn't represent her on things.
All right. So otherwise, she was I guess a family friend.
Oh yeah, good family friend. Yeah. When I was in the hospital, she'd be the one running, get us some groceries along with others, and drove myself and my wife down to the hospital at one point for a doctor's appointment.
It's very nice.
So we're friends.
Did the Board of Assessment Appeals utilize the assessor staff for meeting notices, minutes, scheduling, et cetera?
We tried to, but we at the beginning, we let me see, Vicki Rose was the recording secretary, and we replaced her with Lori. Right, I think our first meeting with Lori Longy, because the minutes from the preceding year, when I went back to look and see what had happened, the minutes for the preceding year were so poor or not done, including votes that weren't even posted yet, that we decided let's have somebody that's on the board that takes notes, that could be a recording secretary. And that's when we appointed Lori. Well, we voted Lori for recording secretary. What was the other part of your question? Oh, for scheduling and things.
Well,
like
so
that?
for example, for scheduling the BA hearings, for processing the applications, for example, for providing public notice for the meetings.
All of that is we rely on Vicki Rose essentially, and she does a great job with that. One thing that they stopped doing for us though during the hearings was scheduling, so that if people couldn't make the schedule that they were appointed with, that they wouldn't call these people back, and if they don't show up, then they lose. As you know, it's somebody, they got to come to a hearing, they got to get sworn in, or you lose. So Donna and Lori then spent a lot of time calling people back, trying to get dates and times to accommodate the taxpayer so they at least would get a hearing And one of the things we did too is because of the volume of all of the applications, we had more hearings than we normally would have. And we also expanded the time for the hearings so that instead of starting at, 5 o'clock or whatever, we tried to start them at 3. And then when we did start them at 3, we were told by, I think it was Vicky through the tax assessor, that because of a union contract or something, that they couldn't provide anybody that early. We'd have to have, we're on our own if we're going to do this at 3 o'clock in the afternoon. And then when we had our first hearing, we get the tax assessor showing up with 2 other people in his office manning tape recorders, that they were there at 3 o'clock, okay, but just not to help us with stuff.
All right, so I just want to make sure I understand
Yeah.
a couple things. So first of all, as far as the clerk work, which would be scheduling meetings.
Yeah. We're also scheduling appointments for the taxpayer.
Yeah, so
Okay,
just
yeah.
so I just want to let me finish my question, just so I want to make sure I understand it. So
Yeah.
with regard to scheduling the hearings, providing legal notice of your meetings, which is required. Was that clear? My understanding is that clerical work was done by Vicky Rose in the assessor's office. Is that correct?
I'd say for the most part, yes. There were 2 other people there too. Pauline Reedy and Alyssa, whose last name I don't know, that also work in the assessor's office. So between the 3 of them, they would get the work done. But our go-to person for me anyway, has always been Vicky Rose, who I like. She's extremely competent. She does a nice job, and she's a good person.
All right,
So
so
that's all I use.
is it fair to say that the assessor's office, the staff in the assessor's office provided those clerical services to the BAA?
Yes,
However, I think you said that when it came, if somebody was unable to make a meeting and they informed the assessor's office, that the assessor's office that staff in the assessor's office was unwilling to assist that property owner with rescheduling their hearing. Is that correct?
yes.
And why, first of all, whom in the assessor's office informed you that they were unwilling to do that?
Well, it was nobody in the assessor's office. Well, wait a second. We would hear it from the taxpayer that would call either Lori, Donna, or myself. Mostly Lori and Donna. And then from the tax assessor's office, when I would call over, I did ask, who's going to be doing this now. And I know that because people had, complained, and I believe it was Vicky Vicky's daughter had a baby and she was taking more time off to be with the baby. So she wasn't around to do some of the on the scheduling. And then the other 2, I never talked to them about scheduling.
All right, so is it fair to say that you're understanding that the assessor's office was unwilling to reschedule appointments when residents or taxpayers were unable to make the scheduled meeting was based on what you heard from taxpayers?
But for almost exclusively what I heard from taxpayers. Now, also, it's the unwilling part also, it might be unable to. In other words, the tax assessor's office might not have been able to handle the volume of these people they're trying to do it. I don't know who's sick, who's in, who's out. We're talking, some people got COVID during this time period. So I don't want to just say, they said we're not doing it. Although there was a big volume, then all of a sudden they weren't doing it anymore. But I don't know exactly whether it's because they were unwilling or unable,
Okay.
so.
Did you or anyone else in the Board of Assessment Appeals reach out to anybody in the assessor's office to inquire about what they were doing as far as trying to accommodate taxpayers who wanted to reschedule their meetings?
Yes, I believe you're gonna ask Donna or Lori that question, but as I told you, I did ask Vicky, and Vicky had told me that she was out because she got maternity with her granddaughter or grandson, whatever it was, and so I'm not going to say, well, that's awful, you drop the kid, come to work, but we handled it, so and the we is mostly Donna and Lori, they were the ones who were calling people back and rescheduling them.
Okay, so is it fair to say that if there was a staffing issue, if the assessor's office wasn't accommodating taxpayers with trying to reschedule meetings, it was probably the result of staffing issues at the
I
time?
wouldn't say probably, I don't know, but it could be that, either unwilling or unable. So I don't know whether it's by design or it's just coincidence.
And certainly you have the appeals of the 22 grand list, which would be coming up in 2023. So if that was an issue, you could also, so I assume you have an opportunity to talk to the assessor's office in advance of the 23 meetings to inquire about whether they would be
And that
willing
is on
to.
our screen now to do once we have a next. The next thing for us, I believe, would be an organizational meeting in March. That's usually what we do. And at that time, we try and iron out any of the issues that we
have. Prior to the BAA meetings, did you know the assessor, Todd Helms?
Never heard of him before. Oh, wait. I shouldn't say that. I don't know him. And also, prior to being asked to be on the board again, I had heard of him, but I didn't know his name.
What did you hear of him?
That he had declared war on the farmers with the Public Act 490. And he was trying to knock off as many farmers as he could from 490 in order to increase the tax grand list.
And was that with regard to farmers in Enfield?
Geez, both. I think it was farmers in Enfield and based on what he had done in Bloomfield.
Prior to starting your work with the Board of Assessment Appeals in 2022, did you have an opportunity to meet with Mr. Helms?
No.
Did he reach out to you to introduce himself to you and to the board?
You know what? Let me see. I interpreted your question to me like in 2021, but you don't mean that. You mean prior to hearing, so when sometime in 2022?
Well, let me clarify the question.
Yeah,
So
okay.
once you were on the Board of Assessment Appeals,
I just thought of one other thing, and one that I think is important too. With regard to your last question about him, or did I hear anything else about him? I should tell you how I got on the board this time, because remember, I had gotten off. I was fat, dumb, and happy at home. I didn't need to get back on this. I received a call from the mayor in December of 2021.
and by the way, who was the mayor?
This was Mr. Crusati, Bob Crusati.
Okay.
He was a decent, honest, good guy.
Was he a Republican or Democrat?
He's a Democrat.
Okay.
So he called and asked me to consider going back on again because he felt that they needed me on the board to help rein in what's happened with this, the chaos caused by the tax assessor. And he asked me, had I heard anything? Actually asked me kind of like what you just said. And I said, well, the only thing I heard is he's declared war on the farmers. And Bob said, well, he's actually declared war on everybody, daycare providers, nonprofits, Mount Carmel, and basically everybody. And would I please go on to help calm the chaos that's going on now? Because apparently he was getting a lot of calls from people. So I thought about it and said, okay, I would go on. And so that's how I got back on for 2022.
So once you got on to the Board of Assessment Appeals, did Mr. Helms reach out to you or the board to introduce himself?
Yes.
Okay, and when was that?
March 10th. March 10th, we had a meeting, Board of Assessment Appeals, one of our organizational meetings. And he came to the meeting and he wanted to talk at that meeting. And I said, well, you're not on the agenda, so we can't. I was uncomfortable with that, but suggested to him, we'll be happy to have a special meeting for you to come back. And then we figured out what time and date would be good. And then he did come back on March 22nd would be the next time we had the meeting where he came in and we were okay to talk because we put it on,
Sure.
So that the public would know if we're talking with the assessor, and because our meetings are public, so somebody could show up.
It's a good idea. I mean, it's the right way to handle it. So when he came back on March 22nd, and you held that meeting, what happened?
Well, we asked him a lot of questions, and he told us some of his philosophies. And I remember he had told us about let's see, classifying land for like OPM gives you the different values for land classification for farmers under 490. And Todd said that as far as he was concerned, he had made a lot of his decisions based upon, let's say, I'm a farmer here and I'm growing tobacco, and the abutting property or the property down the street, I think is what he said, property down the street is growing corn. Then he raised the classification of the land for the guy growing corn to tobacco, because obviously the land should be the same and the soil should be the same, so that you can grow, if one guy can grow tobacco, the other guy can also grow it. So he was reassessing the land at a much higher rate on that basis. And I know that's not true. So as a farmer, that, you know, we had grown corn and our classification is, you know, according to OPM, what it is per acre. And then you grow tobacco, I mean, it's a much higher classification. And also, I believe that's the time Lori asked him if he's a soil scientist. And he said he's not a soil scientist, but he's got experience with a landscaping company. So he knows how this works. That was one thing.
Well, before you move on,
Yeah.
because I want to make sure that I understand some of the things you're telling me. So with regard to the manner in which he talked about reclassifying land, right? You said that, is it correct that it was your understanding that one of the bases for him reclassifying land was based on what different crops could be grown there? Is that correct?
Yes, but also farmer A has grown tobacco, farmer B next door grows corn. There's no change in what either one of them is growing. In other words, farmer B is growing corn here. And then Todd would say, well, you really could grow tobacco, therefore I'm going to reassess you as though it was growing tobacco here, even though there's no change in what the guy's growing.
So is it fair to say then your understanding was that he would change the classification based on what he believed to be the highest and best use, whether that was the actual use? Is that fair?
That's actually a good characterization, yeah.
That's you know, by the way, that's always a tricky area with real estate valuation, and particularly an area that very rarely do you end up with, at least in my experience over the years, an appeal where the parties disagree about the highest and best use. But there are times where you do disagree about the highest and best use. For example, property owner has a huge piece of land and they're using it for industrial use, but it could be subdivided into 75 lots on the water. It's an example I'm thinking of in Norwalk. That's not how they're using it, but that is the highest and best use. And you know, under the valuation analysis, the first step is what is the highest and best use. It's interesting in the context of categorization for 490 and how you employ or how you would use highest and best use. So I think that's an issue that we're going to look into, because I don't know the answer right as I sit here today.
I believe the answer to be, it's not highest and best use, it's use to which you're putting it. So that's just my understanding of it based upon my experiences personally with it in other towns. And in addition, I believe that's what it says in the farm.
Well, it's interesting, and I've got to ask him if that's, you know, and we had one interview, I think I told you with Todd.
Yes.
We're going to do a follow-up. So I think Matt, as you're sitting, I see Matt's on here. On the follow-up, we should confirm whether he did in fact reclassify land based on what he believed to be a higher and better use for crops. And then we'll have to figure out whether that's proper or not. So
Yeah,
that's,
and if I could suggest too, put that down as one of the items you want to talk to Lori about. Because Lori's an appraiser with all this stuff, with tremendous experience in this field. And I believe she'll give you what she believes to be the right answer. And remember, Lori as an appraiser, depending on if you're not in Public Act 490 and you're on for as you were describing, a piece of land down at the shore, well, highest and best use is one thing. But we also had farmers here who some of the farmers are older and they may not grow anything for a year, crop rotation, field rotation, all kinds of things like that, so that they shouldn't be taxed or assessed for tobacco when they're not growing anything. And also could be because of illness, old age, a whole bunch of things happen with people in the farmland, as long as they're not letting it turn back into, trees or.
Well,
growth or
that's
something.
interesting, and
So,
I'll just say that, I mean, I get the law on highest and best use, and and how you're supposed to employ it, how you're supposed to use, deal with the issue under use PAP and stuff like that. So I get it on the real estate side. With regard to whether highest and best use, the highest and best use analysis comes into play when you're dealing with for PA 490 exemptions. I've never actually had the issue posed to me, so we're going to look into that.
Yeah.
But what I was going to say is, you also brought up when it's not being used for farm for farm use,
Well, for growing.
growing.
Yeah.
But essentially, if it's not being used as a farm use because of crop rotation is one thing, which quite frankly, that sounds like it is farm use because it's part of the process.
I wouldn't, the question is loaded, because I think, I wouldn't say it's not being used for farm use, because that's actually a practical application of good farming.
No, I wasn't getting,
technique.
no, I was getting to something
Okay.
else. So
Okay, all right.
I get the crop
I'll try
rotation.
and shut up and listen.
No,
Yeah.
well, yeah, but crop
Yeah.
rotation
Yeah.
makes sense because it's part of your farm process where you want to rotate, right? However, you mentioned if somebody's just not using it as a farm anymore because they're sick or an issue, and it's just, I'm just talking out loud here. It makes me think of abandonment, and under zoning law, there's a high burden to prove abandonment for the municipality. With regard to a PA 490 exemption, I don't think you have to, the issue of abandonment comes up. I think it's either as of a certain date or you're using it for that use or not. So I think on that score, even though you may think, hey, from a fairness standpoint, you shouldn't take the exemption away. I don't think abandonment comes into play with the PA 490 assessment, but you raise the issue, so we'll look into it. So Matt, that's another one we'll put on our list. Is that a fair statement that's your?
Pretty much, and I gotta say, as I was thinking back to our properties.
Which, by the way, just
farms,
interrupt you for a second. The reason I'm saying is because there's questions that the council liaisons did their best to try to help us and say, okay, so what do you guys want us to do here? And they put together a whole list of questions. And so if you've got questions too, that you're posing to a certain extent, I'm going to try to look into those as well. So if the question is it proper for the assessor to take away the exemption for a farm where the farmer for some period of time isn't using it as a farm? I'm not talking about crop rotation. I'm talking about just not using it. We'll look into it. I don't know the answer.
And and a lot of it is the big two words we always know as lawyers. It depends. It depends on what else is going on with the farmer, what else is going on with the land, how long is it in this one and so on. But I want to tell you too, and actually, I don't know of anybody that he did that to, with regard to abandonment. He might have. Lori would know better than I, but
we could just ask him.
Yeah, but with regard to our tobacco farms, we didn't physically grow the tobacco ourselves. We would rent them out, and the people that we rented them to, for instance, we rented to Altadas. They grow one of the largest tobacco growers in the world, and they would get our tobacco, and because it's Connecticut Valley tobacco, they used ours for the outside wrapper on, say, Monte Cristo cigars, which is a very expensive cigar.
Familiar with it?
The deal we had with them was they paid great rent, including every fourth year, they would leave the property alone and pay us anyway, because you want to regenerate your soils.
Crop rotation.
Yeah, it was great. And but they were very, very good, which is why I guess they were so successful in tobacco. So again, if a farmer is because of old age or whatever, not growing something, that doesn't, how do you know that it's not crop rotation without more information on each specific farm? And I would say every piece of property, as you know, is unique. So you got to, take a look at all of that.
When you and I spoke prior to this interview, you mentioned the former assessor and suggested I interview her. I, just so you know, I did call her
Yeah.
last week. She hasn't called me back yet. I will send her a
Yeah.
follow-up email.
Yeah.
What was your experience with the previous assessor, Della Fromont?
Oh, I thought she was fair. She was open-minded. She was very attentive to her duties in scheduling, answer any questions that we may have had. I know I told you I had reached out to her as well as other surrounding town assessors or Board of Assessment Appeals to see what their posture was on the assessor sitting in the room when you're doing the appeals, because we thought it was confrontational. And then also with tape recording, especially while he's sitting there and the appeals are going on. And Della sent me back a letter on that I thought was great. I think I have a copy of it someplace because
She sent you a letter back on what? Could you be more specific?
well, on the issue that we had about tape recording and stuff.
And you're saying that was when she was the assessor, correct?
Yeah, well, we wanted to know when you were assessor, what was the
Or are you referring to when you reached out to Della prior, while you were on the BAA in 2022? Is that correct?
Yeah.
So she was no longer the assessor. You inquired with her about what the past practice was. Is that correct?
Yes. Mhm. Actually, this is her letter that she sent us back, which is part of the exhibit. I think that's the May 28th, 2022 report that we filed. That's,
I think, yeah, I remember.
it's a great, but the letter does explain what she did, and hey, she didn't slam anybody. She was, just talked about, she did scheduling and all that stuff, and but she wasn't in the room when these things happen, but she would be available, and many times we did call and ask her for information or for more stuff. I think it's maybe the second or third.
Yeah, I have this already. I remember reviewing
Okay.
it. I have it. It's attached to your
Okay.
report. So, aside from you talked about Della, did you have any relationship with her prior to, while she was the assessor?
No,
Professional person? Okay.
but I want to finish with this with her too, because the other thing she did is she would contact people before going on their property or before showing up at their business, and just demanding that they drop everything and talk to her at the time, and which is different than what Todd was doing. Todd would just show up at people's properties unannounced and say, I'm the tax assessor, and give me copies of your tax returns or whatever. You're going to have firsthand information on that, I believe. Lori, it happened to Lori, and so she'll be able to address it more.
Okay.
But the only other occasion I had with Della was back in the 70s. I did her divorce for her, but that was in the 70s, and then haven't represented her ever since then. But I was familiar with her working because I think she was in town clerk's office at the time, and she went in the assessors and so on. But she always was a very straightforward, honest person, did her work diligently, and that's it.
What are your thoughts about Vicky? Well, first of all, I assume you've had experience having served prior to 22 on the Board of Assessment Appeals with Vicky Rose. Is that correct?
Oh, yeah.
Do you have any relationship with her professionally or socially?
No.
What's your opinion of Vicky Rose?
Well, I think I already told you, but I like her as a person. I think she's a competent, honest, hardworking, diligent person. She does what she's told in terms of, I think if Todd tells her to do something, she's going to do it and not question her orders. But she's honest in terms of, if I asked her something, she would tell me the truth. And I did from time to time.
And I've interviewed her already.
Yeah.
So My understanding is that the BA first met when you came back on the BA in 22 in February 11th, 2022, special meeting. Does that sound correct?
Yep, all right, yeah.
How many special meetings do you remember how many special meetings you held prior to the BAA holding its hearings?
No, I don't recall.
My notes here say there was three, one February
Mhm.
11th, one March 10th,
Yeah,
and one
I-
March
I
22nd. So that,
remember those two.
okay, so then the
March
other one was
22nd.
February 11th. So sounds
Yeah.
like three, okay. By the way, there's not trick questions
No,
here.
I
I
know,
just,
yeah.
I'm going through my notes.
Yeah.
So did so we talked about the assessor
Mhm.
attending the meeting on March 10th, but you asked him not to speak at that meeting and you asked him to come
Yeah.
back on the 22nd of March, correct?
Yeah, we actually asked him when it's convenient for him
Okay.
to come back, and then March 22nd was the date that was convenient, so that was okay. We then posted a notice, and there was some interest in the public in attending that meeting. So it wasn't just like three of us sitting there with him.
So did you find the discussion with him on March 22nd to be productive?
Productive and disturbing.
All right, so tell me why it was productive and then tell me after that, why
Well,
it was
it was
disturbing.
productive in that he actually told us some of the things that he was doing with regard to especially with regard to farmers. And so I found that productive. I also found, I thought he was truthful, you know what I mean? So we asked him, for example, about he had claimed he was an appraiser, and we couldn't find any evidence of that. And I asked him, are you, you know, like, or maybe Lori asked, I forgot, one of us asked, are you a licensed appraiser? And he did say no. And then with his posture on land classifications and land uses in terms of soil types and all that, I believe when he was done, Lori asked him again, are you a soil scientist? And he said, no, but I got a lot of experience at a landscaping company, or I ran a landscaping company or something of that nature. One of the more disturbing things was he said that with regard to the farm files, which are different than the assessor's other files,
Mhm.
with the farm files, that he was not a good record keeper, and he has been unable to locate a lot of the farm files for the farmers in Enfield. So if he couldn't locate them, then he knocked them all out of 490, and it was up to them to produce proof that they were in 490 and the basis upon which they were in 490 previously. I found that hard to believe. And I did say, geez, you don't think you're under some obligation as a town agency, I mean, to maintain records? And he said, not on these. And then I didn't know the answer to the question, so I called the Farm Bureau and asked, I believe it was Joe Nichols, and I said, you know, what's the situation with somebody that if the town loses the records? And she said that it's up to the farmer to maintain the records, not him. So that was the answer to that question, but it still bothered me because we never had that issue before with Della, or even the assessor prior to that was Joyce something or other, who was very good also.
So is it fair to say that, and my understanding too was that where Todd was unable to locate files, an application,
Mhm.
my understanding was that, that his practice has been whenever there's a revow at that time to review the PA 490 exemptions.
Okay,
And that-
I didn't know that.
And that was his practice. It happened to be that when he came into town, it happened to be a revaluation year, so he did that.
Mhm.
And that if he was unable to find an application, that the property owner, the farm had to file an application, so he had one on file. And so, and I think you verified for me then that you called the Farming Bureau
Mhm.
and they agreed that if the town didn't have an application on file, then it was the obligation of the farmer then to.
Yeah, if they didn't have the
Produce a
back
copy.
records, if they didn't
Yeah.
have the back records, which is why Joan said she told his farmers to maintain copies of all your documents. And I know that when he went to Lori, he showed up at Lori and her husband's, and he didn't know she's on the board, and just showed up there on a Friday afternoon. And it's posted, no trespassing. You see the guy walking around asking, well, who are you? What are you doing here? And then he apparently told her that they couldn't find anything, any of her records. And then, but Lori is meticulous with records. So when she went down to produce her records, they did find her file afterwards. And I'm sure Matt will remind you, ask Lori about that one, because I think that's kind of important.
Okay, and with regard to, so the farmer applications, is it fair to say that you understand that the assessor, it was probably correct for him, it was correct, it wasn't wrong for him to require the farm to produce the application.
No.
However, you feel that that from a service standpoint, the town should make, the assessor should make its best, his or her best effort to try to find the applications and the records, and that the town should maintain good records.
Oh, yeah, they should,
Okay,
yeah, they should have the records. It's just, that's what was, when I
Right.
say disturbing, it was like, all of a sudden, I mean, Joyce had the records, people before them had the records, Della had the records, so now what happened to the records?
well, it's possible,
so-
it's possible that there's some folks that had exemption for a really long time, and the prior two assessors didn't have an application, they just
Mhm.
knew it was always exempt
Could
and
be.
never did anything.
Yeah.
To verify whether
Yeah.
it should have been.
Yeah.
And so,
But he brought it up to me, you know, I mean, he brought it up to us there about how, and the way he brought it up was, this is one of his techniques or tactics for, raising the grand list, because you're deleting, I mean, you're getting rid of some 490s that in his view couldn't prove they're 490, and therefore you're put that on the grand list. That's the reason he was telling us, as though this was like a good thing in terms of thinking outside the box.
did he discuss it in terms of, I'm doing one of the benefits of me doing this is to increase the grand list, or is it, or did he say it was to properly reflect it? Do you remember?
I don't remember his exact words, but it was these things that he touted himself as thinking outside the box in terms of growing your grand list. And he talked about growing the grand list a number of times, but I don't remember exactly.
Did he
what said
specifically
there.
say growing the grand list?
Oh, yeah, growing the grand list.
Okay.
And I believe might be that time or shortly thereafter, Steve Belinda was the assistant town manager, had told me that what he liked about Todd was that he thought outside the box. And I said, the concern I have is, if the box is the existing law, rules, regulations, public policy, that's not a good box to be out of. You want to be in that box. So, but I think that, you know, the administration is probably looking at, this is great because the grand list is growing. And my thing is, say, if you're doing it fairly and equitably throughout the community, that's one thing. But if you're adding artificial ways of growing it to put an undue tax burden on some people who are not as sophisticated to even know what's happened to their farms. So a few of the farmers didn't even know that their property values have been changed, or they have imputed lots now, even though they've signed over their property for to the state, you know, the development rights and so on. So those things, Lori will talk to you about if you and those things we think are
Okay.
they're a problem.
So I still have a lot of ground to cover, and I want
Yeah.
to make sure we have enough time. So I know you've got some time constraints yourself that you mentioned to me earlier. So with regard to Todd's discussion about things that he was doing to grow the grand list, were some of the things that he was doing by way of techniques to try to determine valuations or whether something should be property should or should not be exempt? Is it fair to say that what he was doing was an attempt to try to accurately reflect the grand list?
I don't know what's in his head for it. I took it more that he's trying to knock people off of exemptions that they should have or they had in the past. I don't know about the rest of what's in his head.
With regard to some of the things that he was doing to determine assessments and exemptions. Did you think any of the new, you mentioned techniques or things that he was doing were positive, a good or worthwhile?
I don't know. I really can't answer that one.
Okay. When you guys had that meeting with Todd on the special meeting on March 22nd, did the town manager request that the minutes that were produced from that meeting be amended?
Yes.
Why?
Well, she sent me an email that, I believe was that, the meeting, the minutes didn't reflect what she thought went on for the whole meeting. She wasn't there for the whole meeting anyway. But, we were not happy I've never had anybody, tell an agency, and I've never done that, or a board, what to put in their minutes. And, it appeared as though she was sanitizing the minutes. From that, I actually called the mayor and complained that I thought she was overreaching in terms of telling us change our minutes. I mean, there are minutes. And then the mayor, we discussed the part about the tax assessor not being a licensed appraiser. And Bob Crissati, the mayor, got back to me about a week later and said that he had met with the mayor over my concerns I told him. And the mayor, or to Bob, said that, well, when we go to court, if he's already said he's an appraiser, we don't want people to know he's not an appraiser. And I said, Bob, that's lying. I mean, you can't, so you hold yourself out as an appraiser. And when we find he's not an appraiser, she wants it deleted from our minutes so that people won't know he's really not an appraiser if they go to court. Like, so.
Okay, I understand your concern. So let me ask you, so she asked you to make revisions to the minutes.
Yes.
Did you revise the minutes?
No, we haven't done anything with them so far.
All right, and Matt, you're on here. Matt, do we have those? We have those minutes from that meeting, right?
Yes, we do.
Thank you. All right. Did you, from my notes, it looks like my understanding is that you held appeals between April 4th and April 21st, 2022. Does that sound correct?
Oh, yeah, it was April. Yeah.
I wouldn't remember the exact dates myself a year later, but I just wanted, that's what I have in my notes. So when you did the appeals, did the three members of the board sit together to hear each appeal, or did individual members of the board meet individually with taxpayers?
Both. In fact, if we had, in fact, at the beginning, there was such a volume of them that what we did is we split up so that each of us would hear an appeal at the same time. So we had three appeals going at the same time. And who we got to hear which appeal was all random. So it was, when I was done with hearing one appeal, I just go to whoever's the next in line for their appeal. And then, and so on and so forth, unless there was a reason, there was a conflict or recusal by either me, Lori, or Donna. Now, as appeals went down and then we had less appeals coming in to be heard, then we tried to hear them collectively, three of us. But I know at one point, Lori, I think, got COVID, so she was out for a week. And then maybe the weeks after that, Donna got COVID, she was gone for a week. The only one that didn't get COVID was me, who was the sick one to start. So it's like,
it was crazy.
but I mean, that's, yeah, but that's what we did. And we were tried to give every taxpayer, well, we swore everybody in, and basically I swore everybody in. So that way we know they're getting sworn in, because sometimes Donna might not remember, or Lori at the beginning. So I would swear everybody in, the taxpayer or the agent. And then we did our hearings, and then we would do our deliberations, were all done together.
Is it fair to say that from a practice standpoint, your preference was for all three members of the board to hear each appeal? However, due to shortages, due to the sheer volume resulting from the revaluation and various people being sick with COVID, that that you handled some of the appeals on an individual basis with a member of the BAA.
I'd say most of the appeals, and actually, the way you characterize that question, perfect.
Yeah,
That is exactly right. Sheer volume and
Makes
also our,
sense.
whatever we could do. Our posture preference was of course to have three, but if you can't do three, then you do two or you do one.
which by the way, I think is
Yeah.
best practice.
Yeah.
And so for the 23 appeals, you're probably gonna have a lot less.
Oh, yeah, yeah.
Do you plan on handling the appeals with the full panel of all three, with each appeal if
That
possible?
would be the goal.
And I think it's
Yeah.
best practice.
Yeah.
Certainly you're within the right to do
Mhm.
the individual
Yeah.
hearings. When you heard someone's appeal, did you generally vote that evening on it as a board, or did you wait till a future meeting?
No, I can't recall any we voted on that night. I mean, maybe at the end, a straggler to appeal or so, but basically, we then would meet collectively to deliberate. And then even when we deliberated, we didn't necessarily vote right then either. We would deliberate. Because remember, one of us, like, let's say I heard it. So now I got my stuff and I'm conveying that to Donna and to Lori. And then they have their stuff to convey to me and Donna and so on. And so we would take that home and think about it. And then the next time perhaps we'd meet, or sometime after that, we would actually vote. Because if there was any other questions that we had, you need a little bit of time to think and let it sink in and digest it before voting.
Okay. So after you heard the appeals, you had, my understanding was that you had special meetings in June and July of 2022. Is that correct?
Yes.
All right. And were those meetings properly noticed?
Oh, yeah, yeah. And through Vicky or and the town clerk.
And were minutes kept for those meetings?
Yes.
When you decided to hold those additional meetings, did you reach out to the town attorney to inquire about whether the BAA could hold special meetings in June and July?
No.
Are you aware of whether the BAA has held additional public meetings after it met in the spring in the past?
Yes.
So tell me
We've
about
done
that.
it before, and we did it back in the preceding time when I was on the board, and I know no reason why we couldn't. We have our terms expire December 31st of a year.
All right,
So
is
if
it-
things come in, we hold a meeting. I mean, it's for instance, I got a letter from the town manager about somebody that went before her, and she with regard to an appeal, so she sent it on to me in July. So we were supposed to do with that, so we have a special meeting.
Okay.
I have that with me too. Later on when I go, when you're done with yours, I'll go through mine quickly to make sure. You're covering a lot of territory. I was going to make sure we cover anyway. So
That's fine. At the end, you tell me
not
what
some
you,
others, yeah.
you tell me what else you want to handle,
Yeah.
that you want me to cover, and if
Yeah.
Rachel has anything she thinks I should cover with you, that's
Yeah.
what, let me know. All right, so just so we're clear, it's your it's my understanding that when you were in prior years, when you were on the BAA, it was your recollection that the BAA held some meetings after their general meetings in March to handle appeals, that they may have done so in the past as well.
Yeah.
Okay.
And I don't know any reason why you couldn't. Your board sits until December, well, your term expires December 31st of a given year. I didn't feel I needed to talk to an attorney, but if I did at that point in time, I wouldn't have talked to the town attorney. I would have talked to Rachel.
Okay.
Yes.
So to be frank with you, I've not heard of a BAA meeting in June and July to discuss issues. Having said that, I don't know whether it's improper. I have heard of BAAs prior to the meeting in March and February doing like a training session.
Yeah.
Again, something we'll look into. I don't know the answer yet. Okay, so I guess at some point, is it fair to say there was sort of a brouhaha in town about everything that happened with the reevaluation? There were folks that went to the town council meetings that voiced concerns. Is that fair to say?
I don't know about brouhaha. The chaos started the preceding fall when all this started coming out. And then after some decisions were reached and all of that, then people went to complain to the council.
chaos, whatever it ended up being.
Yeah.
There was
Yeah.
conflict related
Yeah.
to the revaluation in town. Is that fair to say?
Well, I'm using the word chaos.
Okay,
So,
you're describing as chaos, and
Yeah.
that seems reasonable based
Yeah.
on what I've seen so far.
Mhm.
So, did you agree with the decision of the town council to hire an independent law firm to review what happened during the 21 revaluation?
do I personally agree? I think that the decision, when you say independent counsel, is a good decision. I mean, we're the ones that were the springboard for the council to look into this. And if you read our reports are informative to try and let the council know it's exactly what's going on, as well as the public. Our concern was, frankly, that we didn't know how independent you're going to be, because Talberg and Ellen said that there was no connection whatsoever with you, and we know that there were connections. Connections are not conflicts, but there were connections. And so there was a concern about whether you're truly independent. We know that the council didn't pick you to start with a few different times, but Talberg and Ellen kept coming back. They wanted you badly. And we know that if you see what Rachel said on our behalf, BAA, in terms of investigation, we want an independent, fair, thorough investigation that's going to be free of conflict, and it's going to be transparent, so that these problems don't continue, they don't persist, and they get corrected. So that being said, that's, when you ask me what's my mindset when this happens, I'm glad if it's really going to go down that way. But we'll see. And I will say, based on a first conversation that we had forward, I'm provided with, I think I termed it a pretty good level of comfort. You've comforted me with what you had said during our conversation, and even the way you're handling this. So I believe you. I think you are trying to be independent, thorough, and all that. And I just hope it ends up that way.
Yeah,
So-
and I appreciate you saying that as far as our interaction so
Yeah.
far. I'll tell you, just so I'll put it on the record
Mhm.
myself, and I've done this already. I felt like there were some folks who were trying to insinuate that
Mhm.
I had conflicts, or
Mhm.
insinuate things that just weren't true.
Mhm.
And I had to, during my interview with the
Yeah.
council, say, let me stop you. You've made some
Yeah.
comments. No, it's okay. I said, no, I want to
Yeah.
actually clarify for you. So I had never met
Mhm.
Ellen prior to
Mhm.
meeting, after being hired. I don't remember if she was in the council interview. I had never met Ellen before. I had no idea who she was. I think she was a mayor of, was it Berlin or
Bristol.
Bristol?
Yeah.
I had had no interactions with her in Bristol. I don't even remember. I don't remember doing anything in
Mhm.
Bristol myself. Somebody at the council meeting brought up that there was a land use application. So my firm had done something in Bristol. I looked into it, and I think we had done somebody else in my Milford office had done a land use application in Bristol. I had no involvement whatsoever and knew nothing about it. Actually, you know what? For the Connecticut Green Bank, on the solar panel cases, solar panel assessment case I had, I think at some point I talked to town attorney or whoever the person who's representing them in tax appeals, Jeff D'Onofrio, and we resolved the misunderstanding the assessor had in Bristol regarding the assessment of solar panels owned by Connecticut Green Bank. But I have had, that's the only thing I can remember. And then I've dealt with ESPN as my role as a president of Walter Camp Foundation. I dealt with some folks in Bristol there. Other than that, I can't remember anything about Bristol, and I certainly didn't know Ellen. As far as Jim Talberg, he served on he joined the CAMA board, which is the Connecticut Municipal Attorneys Association, as a board member. Within the last few years, I had seen him at some, I've never met him. I don't think I think I met Jim the first time in person when I went to Enfield. Prior to that, I never met him in person. I'd seen him on Zoom.
They wanted you pretty badly, though, but I will say this.
Well, respectfully, I think,
Yeah.
I think for good reason.
Well,
I mean,
that
you
would be
know,
okay. Yeah. And the where I think it started too was Ellen made the comment to somebody, there's no connection. So she didn't use conflict, said connection, and that got people conspiracy theory thinking.
Yeah,
But
I just want to put,
yeah,
I want to put the conspiracy theorists to rest, and to be frank with you, if I thought there was any potential conflict,
Yeah.
I wouldn't even waste my time. To be honest, I wouldn't want to bother with
I have
it.
a good level of confidence in that.
Yeah.
The other thing too is, none of the three of us, to my knowledge, lobbied the council to not have you. We were very careful. We let Rachel speak for where we were coming from this, and we said we'd cooperate, but we'd be really happy if it was transparent, independent, and so on. So but we didn't lobby the council to say, hey, don't get this Mario guy or anything. No, we were stayed aloof from all of that. And there's been a lot of rumors that nothing from your firm, nothing from you, leaks or anything of that nature. But you get people that, especially Todd, that's out there saying different things, and one or two of the council people that are saying different things, and it could be just to try and gaslight somebody. But fortunately, as far as I'm concerned, we turn the gas off. I mean,
Yeah, no,
I
that's.
let it go up like that. Forget it.
And I just, give you the information so that, because I know folks talk.
No, I appreciate your candor.
And, I'll just tell you quickly on the municipal side, what's interesting is when it comes to tax appeals, it's not rocket science.
Mhm.
So, a lot of departments do it in-house.
Mhm.
And so, I represent on the municipal side, I think I probably have the most municipalities on the handling tax assessment appeals in the state of Connecticut.
Mhm.
It's a fairly long list of communities that I represent, and I have others who help me, and
Mhm.
I can't do everything. But there's not a lot of private firms that have a big, a large client base of municipal clients or tax appeals, because again, a lot of them are done in-house, and then town attorneys generally don't like to give them up to other to firms that specialize in it. So for whatever it's worth, it's a fairly small community. And recently I was appointed by, I guess, I don't know if this was officially appointed by the judiciary, but there's a subcommittee that Justice McDonald, who's the Chief Justice of the Supreme Court, appointed to make recommendations to the Rules Committee as to changes to the process in Connecticut for adjudicating tax appeals, starting with form discovery requests. And we're probably gonna have some other recommendations. So there's a 6 member committee, and myself and 2 others are on the municipal side of it. So with regard to recording the BAA appeals, you mentioned that Della said that they weren't recorded in the past, right? But my understanding was that the assessor wanted, that the new assessor, Mr. Helms, wanted to record the meetings in 2022. Is that correct?
Yes.
Okay. And I have an opinion from, and so when he initially requested that, my understanding is that the BA did not want to have the meetings recorded. Is that correct?
Well, he didn't suggest, no, he directed that we were going to tape record the meetings this year. That's what he said.
Okay.
He didn't say, I suggest, would you think, I want to do it? No. BAA was recording them. That's what his posture was.
Okay. So then in response to that, my understanding was the BA initially said they didn't want to have the meetings recorded. Is that correct?
Absolutely. Yeah.
And then there was I'm just trying to go through this a little quicker so that we can keep moving. Stop me if I'm going too fast. So there's a letter from a legal opinion from Jim Talbert to Ellen Sasso, dated March 30th, 2022, in which he opined as to whether the town may have audio record BA hearings. The short answer was yes, audio recordings of the BA may be made, and that his opinion was it uses the BA uses town facilities, conducts town business regarding assessment appeals, that he's not aware of any statute, rule, or regulation that will prevent the town from taping hearings in order to provide an accurate record of the proceedings. That being the case, he would recommend proceeding with taping the hearings. pretty short opinion. Did you agree with the town attorney's opinion regarding the taping of BAA hearings?
No.
Why?
Well, I'm looking at my own minutes from the recording of with regard to setting the record straight on that issue you're talking about. And so back on March 11th of 2022 is when Vicky Rose sent us an email saying this year the BAA will record all hearings. So on the 15th, I had a conversation with her saying that you know, it looks like this was not written by you. This was somebody else that wrote it. So who wrote it and told you to put it under your email? And she said, my superior, Todd Helms. After authoring the email, Todd had directed her to send it to me under her name without attribution to him. So I said, well, relay a message back to the assessor that the BAA would not record its own hearings this year. And she did not know why Todd did not want to reveal his role in ghostwriting her email. So I then, on March 29th, I got an email from the town manager, which I have in here if you want it, but I'm sure you guys got it, telling me our extension request would be granted and more appropriate hearing locations were being sought. These are things we were brought to her attention. And then she said that town attorney Talbert will shortly be forwarding you an opinion about taping the appeals process or proceedings. This puzzled me since we hadn't requested an opinion, nor had the members been contacted previously by either the manager or the town attorney about any of these hearings. And then she expressed her personal opinion about the special meeting draft minutes and requesting that we amend it, basically to get rid of some of the references to the tax assessor Todd Helms, with which she disagreed. So on March 30th, I received a copy of the email from Attorney Talbert to the manager, purporting to give his legal opinion. And the process never sought to involve me or any other BAA member to verify the so-called facts upon which the opinion was based. No facts were sourced. The portrayal of my alleged position was incomplete and misleading. My alleged statement was neither sourced nor attributed. And actually, if true, I thought that a mischaracterization puts me for violating FOI laws. My position as chairman and the BAA policy is that the audio recording of BAA proceedings by the public has been allowed consistent with the Freedom of Information Act under 1-226 or previously 1-21A, at least since I first was appointed to the BAA over 10 years ago. And to my knowledge, no member of the public has ever been denied their right to record any BAA hearing, meeting, or proceeding. So on that issue, we were concerned, the BAA, about why we weren't contacted ahead of time about a legal opinion that concerns us. Who was it that asked for the legal opinion? And we believe it was the manager or Todd, because he wouldn't want his name on it. And then why were we not contacted after it was requested in order to confirm or refute facts? Especially with regard to existing BAA policy. Finally, the opinion implies the BAA should tape record its own hearings. We thought it's short-sighted, fatally flawed for a bunch of other reasons. And so some of the other reasons, I'll skip over because I'm sure you.
I read, by the way, I read,
Yeah.
this is a statement from the BA regarding recordings, which was dated April 4th, 2022, correct?
Yes.
So I've reviewed this, I have it here.
I know, but it's on video right now and I'm being asked it. So I want to memorialize it in case somebody else wants to look later and say, well, Tyler didn't complain.
I just want to let you know that I did review it and
I assume
also
you have, yeah, but this is.
That's fine. And also, you know, in the record that we will be producing regarding the review, this will be in it, but I'll let you continue.
Yeah, this is, I thought, most important part is, since we're not versed nor proficient in the operation of recording devices, nor do we have the time or desire to interrupt hearings to make these recordings, we did not want to assume responsibility to keep recorders in good working order, ensure accuracy. And we didn't think it was appropriate for the BAA to be perceived as acting as an agent or an arm of the town's tax assessor. Many of the cases involve personal or financial information not subject to public disclosure. It's virtually impossible for us as BAA members to monitor, screen, redact, or otherwise guard against the accidental acquisition or subsequent release of protected, confidential, or privileged information in violation of the law, which put the town and us in legal jeopardy. Again, we just didn't think it was appropriate for us to be doing this. and well beyond the nature and scope of our statutory authority. And most importantly, I'm skipping a little bit of this stuff. Most importantly, we didn't want to participate in the BAA being pressured or bullied into recording our proceedings. It's intimidating to most people who are already anxious and nervous. We thought it'd have a chilling effect on them as they try to present their cases. Most of these people are not attorneys. They should not feel as though they're being interrogated at an inquisition. BAA hearings should be conducted in a dignified and orderly manner. But one of our goals is to provide an atmosphere as comfortable as possible, so citizens and taxpayers do not feel threatened, intimidated, or bullied by their own government, be it the BAA or town officials. Additionally, one other thought was that while you've got these tape recordings going on, a lot of the taxpayers are there with their lawyer. So now if we have a break and they ask for a timeout, who's going to be there to shut off the tape recorder while there's privileged communications going on between the lawyer and the taxpayer? We don't want to be responsible for that. And that was never addressed by what they ended up doing during these proceedings. So.
And as a result, but my understanding was that at some point the BAA, I guess, begrudgingly agreed to tape the meetings. Or
no, absolutely not.
So you never taped
not.
those meetings, right?
No. Well, we did not tape them. Todd Helms came in, sat behind people. He got another secretary to sit behind, if we're doing 3 at a time, got 2 other secretaries there with tape recording machines going on. He taped them. We warned everyone who came in, besides swearing them in, you're being tape recorded. And then I know that after a while, he didn't have 3 people there. He would either get to the room before we got there or after we got there, if I went to the bathroom, and he would hide a tape recorder like in a coat rack where people wouldn't even know they're being tape recorded. So that's what happened with that.
So but the bottom line is the assessor's office recorded the BAA meetings.
Yes.
Okay.
Mhm.
And then so on your statement on behalf of the BAA dated April 4th, 2022 regarding the BAA, the tapings, on the last page, you the second paragraph, last page, you stated many cases involve personal and or financial information not subject to public disclosure. And then it goes on to say it'd be impossible for the BAA to monitor, screen, redact, or otherwise guard against accidental acquisition of and or subsequent release of protected confidential privileged information in violation of law. However, when someone applies to the BAA, let's say I file an application and I give you in regards to a property that's commercial under $1 million. If I put in my BAA application, you know, here's what the actual income and expenses are, and here's what the actual NOI is. I think the assessor's too high. I mean, whatever I submit is a public document, right?
I don't know that. It depends. Everything depends. And I'm not as concerned with the commercial people as I was with the individual farmers or individuals that were coming in that might be talking about, well, so-and-so is getting divorced, so I can't do anything this week or whatever. Those issues don't belong in the public. And also if they brought tax returns, their own personal tax returns, and they want to give them to us, you know, I wasn't sure whether it's subject to public disclosure or not, but the purpose of tape recording would be destroying a lot of this that could be privileged information. And I didn't want to be responsible, nor did the others, in trying to figure out, as we sit there and listen to these people with their grievances, to go over all of their financial documents and see, well, what is or what isn't subject to public disclosure. What we would do without the tape recordings, for instance, we would take whatever they gave us, and then that would become part of what we would hand over eventually to either the tax assessor or the town clerk and let them figure out what is or is not subject to FOI.
So, at any time for the 22 appeals, did you or anybody from the BAA reach out to the town attorney to inquire about whether any of the information and documentation provided during the BAA appeals were in fact not subject to public disclosure?
We reached out to Rachel Baird, who was acting as the attorney for us, on the basis that the town attorney was so conflicted with protecting Todd and concerned about his issues that just we didn't feel any confidence in him being able to give us a fair, impartial opinion on anything that we had. After this thing started going, we reached a point where it was just senseless to even try and talk to him, thinking we could get a straight answer.
Did Attorney Beard provide, did you ever inquire with Attorney Beard or anyone else in the BAA about whether any of the information or documentation provided in the appeals or during the process was privileged or confidential?
With regard to a specific application?
With regard to any
No, we would no, we wouldn't discuss that. There'd be a specific application. We would not then feel comfortable talking with Rachel about a specific application. Generically, I would call her from time to time with questions.
But I guess
but not specifically on, Joe Smith said this, he gave us this, what do you think? No, we would not do that.
my understanding is from the April 4th, 2022 statement on behalf of the BAA that one of the concerns raised about taping the BAA hearings was that many of the, according to the statement that you provided, that many of the cases involve personal and financial information not subject to public disclosure. So because that was one of the stated reasons as to why you didn't want the meetings taped.
Yeah.
I'm trying to figure out if you or anyone else, the BAA, had ever inquired with either the town attorney or your own counsel to confirm. Is there any information or documents in the process that's provided that is in fact not subject to public disclosure? Is that understanding that you
could be
correct?
somebody that gives us something? I mean, my concern wasn't what the town was giving us. My concern was what the taxpayer
I understand.
was giving us.
So the meetings, the hearings that you hold for the BAA are public, correct?
Yes,
So for example, if a member of the press wanted to sit in on every single BAA hearing, they had a right to do so, right?
and the press was there for some.
Could I just interrupt, because I'm sitting here objectively listening to this conversation, and I think there's a disconnect. Attorney Paul, you just said did not want the meetings taped. That's not what Attorney Tyler said. He said the BAA didn't want to tape the meetings. He never said he didn't allow the public to tape the meetings. So
That's not what that's not what I was suggesting.
okay, good.
So
I
just so
wanna
we're
make that clear.
just so we're clear, you made it very clear to me that when you were on the BA in 22 and in years prior, you always allowed any member of the public who wanted to tape a meeting to do so.
Right.
And that you had no issue with that.
Right.
And that one of the stated concerns that you had about taping the meetings was that was not the applicant doing it because they could tape all they want, but that if the meetings were taped by the assessor's office and then made public
Well, by the
that-
government, yeah.
by the government,
Mhm.
that anything said during the hearing
Mhm.
would now be subject to disclosure, and there could be confidential information or privileged information that's provided that otherwise would be taped. So my understanding is that at least from the statement that you gave on April 4th, that you had a concern about the fact your understanding at the time that some of the information or documentation may not be subject to public disclosure. Aside from whether it's legal or not for public disclosure, did you have a concern that a taxpayer could come to appeal something, not realize that something is subject to public disclosure, and that there's an unintended consequence that if you tape the hearing, they may say something that they didn't want others to hear? Was that, I don't want to put words in your mouth. Was that let me put it this way. Let's assume we find out that the law says anything you submit in the BAA is not privileged, it's subject to disclosure. Irrespective of that issue, did you also have a concern that regardless of whether the law allows information or documentation in the BAA process to be disclosed, that all taxpayers may not realize that it's going to be disclosed, and that there's a concern that you had a concern that folks may say something or provide something in a meeting that they didn't intend for everybody to see? Was that a concern that you had?
I'd say that's pretty accurately stated.
That's what was there anything inaccurate about that?
No, it's like
Understand.
just thinking back to people that come in and would tell us about their marital situation, which got nothing to do with the price of rice in China, or they tell us that so-and-so's dying of cancer, or this one's got that going on. It's irrelevant, immaterial, but once the cat's out of the bag, if it's recorded, then, people can do whatever they want. But I will say this too. We gave warnings to everybody when they came in, because the tax assessor was the government tape recording as opposed to a private individual. In years past, I don't recall ever giving any warning to everybody that, hey, somebody could be taping this, or it's, public information. We didn't bother with any of that.
In your April 4th, 22 statement, on behalf of the BAA, you also mentioned chain of custody issues. And quite frankly, I was confused by the statement. It was in the third paragraph of the last page. You said, due to the sheer volume of appeals, it's completely unreasonable for the town to expect us to undertake responsibilities of transmitting and or safeguarding these tapes in compliance with custodial obligations, which could be legally imputed. Those chain of custody issues are most formidable and well beyond our capabilities. We absolutely decline to accept responsibility for such preservation of evidence duties. Was it with regard to that statement, was it your position that you had a concern that if the meetings were taped, at some point somebody may lose the tapes?
Now, if we're responsible, again, if we're responsible for tape recording, then we're responsible for chain of custody with regard to the recordings themselves, and making sure that if somebody wants a copy later or the court needs them, then we're responsible. We don't want to be responsible for them. So again, Todd did his tape recording. He's responsible for the recordings, not us. If somebody else does they're responsible for it. Or for the BAA, for tape record, then we take on all these other issues that we didn't even understand, that we don't want to be responsible for.
So just so we're clear, the reason I'm asking is, so was another concern you had about taping the meetings that there would then be a responsibility, not for the assessor's office, but rather for the BAA to somehow maintain these tapes?
Of course.
And that
if we're the ones that are tape recording, then it's our responsibility. If you're going to do it, you got to do it right. You got to make sure the machines are working correctly. You're picking up what you should pick up. You're not picking up things that are privileged communications outside of the scope of the hearings, but happen to be in the same room between a lawyer and his client. And again, you become responsible now for safeguarding those and maintaining chain of custody in terms of if you have a court case on it, civil case, criminal, who knows what can come out of these things. So we didn't want to be responsible for it.
and my understanding, well, not my understanding, it's from what I read in your April 4th, 22 statement, that you felt the BA was being pressured or bullied into the recordings, and that it was intimidating to most people who are already anxious and nervous, and it would have a chilling effect on them if they had to present their cases with the tape recordings. Is that your concern?
Yeah.
And did any taxpayers express to you concerns about the taping?
Yes, a number of them did. Some during the hearings, most afterwards. To me, as well as the other members, I believe they also got.
What were the concerns that
well, they thought it
taxpayers
was intimidating. They use the word intimidating many times, to have the tax assessor sitting there in the same room while they're trying to make their case.
So,
And also on tape recording.
So now,
Just people get nervous. You gotta remember, Mario, a lot of these people, we've never seen them before. In the 10 years I was on, a lot of these appeals came in from people I had never seen before, but they're here because they're all upset, nervous. They're not used to this. You do a lot of appeals. I've done some court work, so we're used to if somebody wants to tape record, okay, your video. I mean, that's okay, fine. But to a normal citizen that comes in, they find it intimidating.
makes sense.
Yeah.
So you have the 23 appeals, the appeals from the 22 grand list, which are going to be adjudicated by the BAA, I would assume in March of 23 this year. Or April?
Yeah, March well, March have our meetings. I think it's April, unless they continue it, because sometimes the assessor has to get the grand list done, but whenever it is, it's spring. And then I believe in September, we do cars.
All right, so at some point in March or April, you're gonna have your BAA hearings, correct?
Yeah.
All right, and when you do those, is your understanding the assessor's office will take those meetings again?
I have no idea. We're gonna have an organizational meeting. We intend to ask and to invite him. And then we have our list of things that we wanna see improved, including scheduling, and of course, I don't have a plan to ask him, are you gonna tape record again? I'm just assuming he's probably gonna do the same thing he's done before.
Aside from being more accommodating to taxpayers who want to change their meetings that they've been assigned, is there any other requests that you'll have for the assessor's office with regard to the BAA hearing process?
Thanks. Hold on a minute. Let's see. Yeah, if I can back up a little bit only on one thing, you asked about these special meetings or meetings outside of the scope of when you're doing your hearings and all that. Remember you had said you'd like wait a meeting in July, meeting
Yes.
in November, why you do this?
Well, it was June and my recollection was June and
Oh,
July.
no, in November also.
Okay.
So they all have, but they're all for specific purposes. And the first thing I noticed here is that there was a meeting BAA had last year, preceding the fall of 2021, after all their appeals are done and so on. And what they did is they revised their appeal application form. And then they could post it online through the town. And this is before I was even appointed. So that's one of the times they have a meeting when you're not having hearings. And the tax assessor then made changes to the form, making it harder to fill out and comply with by people. So one of the things that he required on the form is if you're going to have an appraisal, you got to have it filed with your appeal, a complete appraisal. And then he put it on the website. Well, one of the members, and I think it was Donna, but I'm not positive, noticed the changes, and then contacted the assessor's office and said, we just went through and revised our appeal application form. That's the one we want. We don't want the new assessor making a change unilaterally, usurping our authority and putting it on. So that happened before I got on. Then let's see. Yeah, well, when we were doing our appeals, we wanted a spreadsheet on the appeals that would put on the grand list values as of the preceding year, not just the current year. We wanted, as well as putting on the applicant's fair market value and which had been on in prior years. The tax assessor had directed Vicky, I believe, to delete those. So we were provided less information rather than more information. So we'll be asking them about that to make sure that the spreadsheets are with what we want, in addition to whatever he wants to give us. And then he last year had made claims to the taxpayers that he's received notice from the Department of Motor Vehicles that initiated him, saying that they had to give him all this information about their motor vehicles. Do you recall that letter in my exhibits?
I do, and my recollection was that there was a letter that I believe was a form letter that the assessor sent out to certain taxpayers regarding motor vehicle assessments, and that there was a reference made to a request from the state of Connecticut. Is that correct?
Well, it's more than that. He said that the genesis of this letter that you're receiving is because motor vehicle department told me that you registered something, and then he goes on with
Yeah,
the
that's
rest of the
what
letter.
I'm
Okay.
referencing.
But he didn't receive anything from motor vehicle that would have justified him saying that in the letter, and no motor vehicle hadn't sent him any letter on the majority of what he sent out.
Matt, could you get off me for a second, moment? So we did ask the assessor about that when we've interviewed him, and as I think I already told you, Tom, our intention was to do the initial interview with him.
Yes.
which
And
is
they
fairly
did.
extensive, and then do at the end, a follow-up if I needed to. Matt, my recollection was we did ask Assessor about that we have the form letter we do have the form letter that he sent out to everybody, correct, Matt?
Yes, we do have.
And
the
my
form.
understanding was that, yeah, and my understanding was that he had confirmed that the statement may not have been completely accurate as far as contact from the state, correct?
Correct.
We addressed that with him in his interview. So
Yes,
I have
we
the
did.
letter.
Yes,
I so you
Yeah.
figured I have that already.
Yeah.
Yeah, we addressed it with him, and my recollection was that in following letters that he sent after that, and Matt, that's just my recollection. I may be wrong on that he changed the language.
He either, I'm not sure.
Or
if
he's
any
go- or
letters
he
that
was
have
going
changed
to
language
going
have
forward.
gone out, but he has changed the language. So letters sent out in the future, and we can go back and clarify exactly what he said. But yes, the letter has been changed.
So, but yeah, so my recollection, all right, so the letter's been changed.
Well, we may be looking at this through different lenses then, because when I look at what he said. I forgot how you characterized it, but when he says the state motor vehicle department has notified our office that you've recently registered the below listed vehicle in town of Enfield. That statement's false. I asked him that point blank,
No, I understand. We're looking
Okay.
at through the same
Okay.
lens. I asked him
but
similar questions about the origin of the letter, and I don't want to paraphrase inaccurately what his responses were, but I looked into it, and I could tell you that I got responses from him as to exactly what happened and what contact there was for motor vehicles, et cetera, and I addressed it all in the interview with him, so I
Okay.
covered it.
well, after he had sent this to people, when people did call him saying, hey, wait a second, some people thought it was identity theft because they hadn't switched anything. Others, he was asking for motor vehicles that were, this is 1991, that had been in the same company for a number of years. And these people characterized what he did as devious, deceitful, false. And also when they called up to complain about, well, what's motor vehicle doing? Todd still told them that you still had to comply with this, or I'm gonna assess you for the highest possible values I can put on your motor vehicle. So we're still gonna talk to him about this anyway, because there's gotta be a better way to improve your social skills. To talk to people, if you goofed up or you made a mistake or whatever, I mean, you don't compound it by continuing to threaten people with higher taxes if they don't comply with something they don't have to comply with based upon a false statement from the beginning.
I don't know if they,
That's
I don't know if, I don't know if I would make the assumption that they don't have to comply with the request for the information. With regard to the false statement from DMV, with regard to references, state of Connecticut, we addressed that in the interview. But I will, Matt, just make a note, please. Let's make sure that I'll make a note here as well. That Mr. Tyler's brought up or has raised a concern about whether he could request the information that's sought in that form letter. And
Actually, it's different than what you just said.
Okay.
I'm not saying he can't request it. I'm saying he can't request it on the basis of a false statement.
All right, so scratch
So,
that then,
For
Matt.
instance, let's say,
I understood what I understood
so
that.
if he says, if he didn't say state motor vehicle, if you left the first sentence
I
out,
understand that.
I don't have a problem with
Right.
it. He can ask for anything he wants.
I thought you were saying
Okay.
you had a
No.
concern about a mass, okay, because I thought he had the right
But-
to, but I just figured I'd
Oh, I
check.
don't have a problem with that. It's the first sentence that then leads people.
Yeah,
into
we already
thinking,
addressed
oh my
that. We
God.
addressed that with him. I
Okay.
think that issue is resolved.
Okay,
So I chalk that one up to, hindsight's 20/20 and he's improving his process. So that, but we'll address that in the
Okay,
report
then-
as well.
the other things we want to talk to him about is getting our minutes and agendas posted online quicker at the tax assessors, but also through the town clerk. We think that this information should be online. not
Minutes or
suppressed.
notices?
Well, notices, absolutely, they have to, but we'd like our minutes online too, so people know what's.
Are they
going
online
on.
now?
I don't know.
Matt, let's just make a note that I think the minutes are, let's double check. If they're not on, then we should make a note that that's something the BAA wants.
Yeah. And then the reval budget, we thought it was, we didn't get enough information from them, like from Vision. So that for us to find out Vision's Bible or their whatever the thing is, their
Manual.
the manual. We had to actually go into the tax assessor's office to read it, at which point I said, this is ridiculous. So I said, and I asked Vicky, I said, can I buy it? And she said, yes. So I paid him $100 to buy it so that then we each could have a copy
Why did you have to buy it?
because the town wouldn't provide it to us.
Alright.
And it
So-
was the vision, the manual that we were talking about afterwards that I think
I want to make sure we get this
Donna
right.
will take it. Yeah,
Matt, let's make sure we put a note that when we follow back up with the assessor, I want to find out if the BAA was required to pay for the revaluation manual. And my assumption is it would have been for the copy of it. But I'd like to ask if they were, how much were they charged and
$100.
why wasn't it?
Yeah.
Why wasn't it provided to them at no cost?
Yeah, and what happens?
If you don't mind, from time to time, I
No,
want to
that-
make sure we don't,
This is, believe
Just
me, I
easier
love
for
the
you.
discourse back and
if
forth.
you don't mind, just.
So I remember with Vicky, I paid $100, but I didn't want the printed one. I wanted the one you could pass on as an attachment. And so I could give it to the other two members also, so they didn't have to pay the same thing.
Did they give it to you electronically?
They did, yes, and then I passed it on to them.
Um,
So,
my opinion is that the
Yeah.
BAA wants. If the BAA wants copies of the revow manual,
Yeah.
the BAA members shouldn't have to pay for it because it's
Correct.
part of their job.
Yeah.
We'll look into that.
yeah, thank you. And then one of the things, next year's budget, they gave us that at one meeting. When we had an adequate notice or no time to discuss with the budget, what, what was it gonna be? And then when we even looked at it, it's one page, the numbers didn't even add up correctly. And they just didn't have time for us to digest it and have another meeting, so they just shipped it in for this year. Now, this year's budget, she just sent me over the weekend, and so I asked her for the last 3 years, so that when we can have a meeting and then get back to them by March 7th, I think they wanted. And then of course, the other thing is, for all these hundreds of hours that we put in, even though they have a budget to pay us, we haven't been paid.
Do BAA members get paid in
Yeah.
Enfield?
Yeah, you get paid.
How do you get paid in Enfield?
Well, they give us a stipend for number of hours that we put in each year and pay us. But this year, one of the obstacles they had is they thought, I think if they make it hard for us and they don't give us the manual and they don't pay us, then we'll throw up our hands and say the hell with it.
What is the stipend?
It depends on how many hours we put in. I think what we were paid in the past is like $25 an hour for our time for doing all this. And one of the things that Lori and Donna did that they understand better than I is they actually created a form for 490 farmers, which you'll see with the decisions that were made. They created this form so that any of the land that had been declassified or classified as something else, we used OPM numbers and put it back where it should have been before Todd had taken it out. So they made this that form. I mean, it took them a lot of time to do this on their own.
So
Yeah.
I want to ask a follow-up question
Yeah.
on the pay. So is it your understanding that BAA members get paid $25 an hour for their time?
That's what I think so. But remember, I haven't been on there for a while. I got back on last year. I know I didn't get paid and they didn't get paid. And also they have in their budget like an extra $800 for recording secretary. And Lori's our recording secretary, not Vicky, but Lori never got that either.
So
We have not demanded it either because we're more concerned and focused on trying to do a great job to treat everybody fairly, equitably, and so on. So we haven't demanded it yet.
so did you send invoices for your
No,
time?
no, that's why I said we haven't demanded it yet.
But in the
We
past,
never did in the past. No, they just send us the checks.
so in the past, when you were on the BAA, they would just send you a check for.
Yeah. Send a check twice a year, once after the real property and then the other one after the autos.
All right, Matt, let's make a note to look into the payment records for the BAA. I think Bridgeport, I heard may have gotten, BAA members may have gotten paid. To be honest with you, in all the towns I work with, none of the BAA
Yeah,
members
from
get
10
paid.
years ago, when I first went on, you got paid. You don't get paid a lot of money. But and you don't do it for the money, because obviously,
I've never
you
worked
would
with a
do
board
this.
that's gotten paid. I was just,
yeah,
uh,
okay.
part of me is curious, so, that's good.
Yeah.
Okay,
That's pretty much what we were gonna talk to him about. And of course, scheduling, so that we have
okay,
that all set.
so let me continue with my question. So, if at any point you want to take a break, let me know.
No, I'm good.
All right, Rachel, if any, when you want to take a break, let me know, please. So, I want to talk to you about your report. There was a report that was issued on behalf of the Enfield Board of Assessment Appeals titled Enfield Board of Assessment Appeals Report on Decisions of Appeals of Assessments heard in April 2022 and decided in May 2022. That document was dated May 28th, 2022, correct?
Yes.
Did you author that document?
I did the initial writing of the draft and then bounced it off everybody to come up with the final, but basically that's my work.
But when you issued the statement,
Mhm.
did you confirm with the other two BAA members that they had accepted what you had provided as a report on behalf of all three BAA members?
Yeah, I think that's what it says at the end. There's a part of the minutes.
That was my recollection, yeah.
Yeah.
Okay.
And we had gone over it as time was going on. I mean, I didn't just sit down and write this in 20 minutes. So this is, as time is going on, we're talking about this during the any loans.
I assumed.
Yeah.
I assumed that this
Yeah.
took time to prepare. Okay, so what compelled you to issue this report?
Well, can I see it?
Sure.
Thanks. Funny, that one I didn't bring with me.
And
Yeah.
Rachel wants to make a copy. That's
Well, I think you already have it, but anyway. Well, it's basically what I said here, which is the purpose of the report is to address issues raised in the appeals in general rather than specific. I didn't want to talk about specific appeals and decisions or deliberations. And the intent was to provide future guidance for the tax assessor's office as well as the public. And the reason that we were even doing it, even though I don't think it's ever been done before, and there were no circumstances under which we had to do it. We just felt that because of the large number of BAA appeals, then they revolved around the interpretation of Public Act 490 and reclassification assessment, personal property, motor and motor vehicles, reporting requirements, assessments, and other ordinary appeal topics, that there was such chaos and such a clamoring from the public that we thought this is one way of addressing it so that we don't have to face this again in the future. So we looked at it as constructive criticism.
One of the issues you addressed in that report was the assessment, was an assessment of the work done by Vision Government Solutions, the revaluation company, correct?
Yes,
And at some point in the report, you concluded that Vision's report was more than just a little flawed, correct?
yes.
Did you or anyone else in the BAA reach out to anybody at Vision with respect to their work to discuss it with them?
I think Donna will address this for you. I believe Donna did.
Okay.
And I know that one of the things that was told to us as we're concerned about the question on, they said the determinations influenced by interviews with knowledgeable local brokers and real estate agents. And then we find out there was nobody local that they talked to. The closest one was somebody in Wallingford. And that's all described in the report. But I think the other things too is, number two is failure to provide consistent depreciation schedules. Again, that would be Donna or Lori that are really good on that stuff. So they'll be able to tell you what
the concerns
they're
were.
talking about.
Okay.
Yeah. And then the third one is the creation of the Fountain of Youth formula that
Hold that, because I'm gonna get to some
Oh,
questions on that,
okay,
but
go
I'm gonna get to it all, but let me ask, so my understanding is that you stated that Donna
mhm,
spoke with someone at Vision, right?
I believe so.
Okay. And did Donna convey to you what her discussion was with Vision?
Yeah, because we put it in here. No, when I say Vision, she might have done it through Todd. And then Todd talked to Vision and then back to Donna, but you gotta ask Donna.
Okay, so I'll ask
So-
her. Did you or anyone, did you talk to any, did you discuss your concerns about Vision's work with the assessor?
No.
Do you know
Oh,
if any?
excuse me, other than when he initially was with us, I remember asking him the question about who are these local brokers and real estate agents? I remember asking him that back on March 22nd. And he did not know, I was gonna get back to us. But then Donna took over from there. That's the only occasion I would have had to ask him anything about it.
Are you aware that Vision had conducted the prior three revaluations with the town of Enfield?
I'm aware of at least one of them that was on the board and probably two of them, that I was on the board previously. Well, whether it's Vision, not Vision, I would not recollect. It didn't make any difference to me who it was that was doing it.
When you were previously on the
Mhm.
BAA, assuming that Vision had
Mhm.
done the revaluation or revaluations that
Mhm.
were that took place
Mhm.
during that time, do you remember having any concerns about the revaluation company's work?
I had a concern that I expressed to Della, I believe, over the people just showing up at somebody's house unannounced or running around their property. And she said that they have badges, that they put out notices and they try to notify people. But the reason for that was I get a call from my wife that some peeping Tom is peeking through the windows. So I race home and you find out it's a guy from Vision, or he says, well, I'm from the town. It's, can't go up. He said, well, I was measuring the outside, but my wife looks at it like he's peeping Toms. And I know that Della then changed it so that these guys would let people know, you just can't do this. In fact, you go to the wrong property, you're gonna get shot, depending on what's going on there. So
You never know
yeah.
today. Yeah, you gotta be
and
careful.
so now our property's not fenced, it's not posted, but it still is, just common courtesy to let people know I'm coming.
Got
And
it.
with that, one more thing. Donna and Lori would go and independently verify some of the statements that were either made by a taxpayer. Like when taxpayer says, geez, he's assessed me for 9 barns, I only get 6. Well, they would actually drive by and count them, and so they did work outside, which you can ask them about. And, but in so doing, they would always tell the taxpayer, is it okay if I go and check this? And they would not do surprise visits, like in the middle of the night with a search warrant or something.
On page 2 of that report,
Yeah.
you made a reference to the reliance on local brokers and real estate agents.
Yeah.
How, in your opinion, did that misstatement, or at least what you believe to be a misstatement, affect the assessment of properties in Enfield?
Not credible.
So essentially, your concern was that by stating that they spoke with local broker, that they can conferred with local brokers,
Mm-hmm.
and to find out that they didn't, but rather only conferred with a broker, at least according to your research,
Mm-hmm.
a broker in Wallingford,
Mhm.
that it affected their credibility.
Yeah.
That's-
When you tell me this determination is also influenced by interviews, plural, with knowledgeable local brokers and real estate agents, plural, then you find out it's not local and it's not plural. So it's who did they interview in order to come up with this stuff? And when they basically have nobody they interviewed from Enfield or any of the surrounding towns, which we consider them local. I mean, if you talk to somebody in Southfield, okay, close enough. But that to me affects somebody's credibility, because to me it's false.
Did you or anyone on the BAA look into whether the revaluation company conferred with or asked about properties with the assessor or the prior assessor or anyone else in the assessor's office to get an idea of the local market?
Why would we? They said determinations influenced by interviews with knowledgeable local brokers and real estate agents. We find out that's false. So I don't know if Donna did, but I think that's expecting a lot from a Board of Assessment Appeals to find out what they told you is false and then say, oh, let me go ask the same people that you don't have faith in their credibility. Gee, is there anything else you want to tell us? When they wouldn't even give us the manual. I mean, there's a lot of steps we had before we got to May that destroyed the credibility of the tax assessor as well as Vision.
There was a concern raised in that report about inconsistent depreciation schedules. I was gonna ask you what you meant by that, but you want me to talk to Don?
Oh, yeah,
Okay.
definitely. That's, remember, this report is done with, as. our-
I got
all
you
our
explained it.
deliberations.
Got it, got it.
And so,
You explained it. I'm
Okay.
just gonna make a note to ask Donna. Okay, same thing with depreciation schedule. Should I ask Donna?
Donna and Lori too. I think Lori may know something about it also. And the same with number 3.
Okay. And how about okay, so those,
Mhm.
I'll ask Donna and Lori. Okay,
Mhm.
got it. The Fountain of Youth formula.
Yeah.
So, what did you mean by that?
Well, they changed the dates on people's street cards. So it would make residential properties look like, let's say it was built in 1975. They'd say it was built in 1990. Because then it's more recent, which would increase the value.
Are you referring to the effective year versus the actual
Yeah.
year? Okay, so the actual year would be the year the property was constructed, correct?
Yeah, you know what? I'm not comfortable answering this.
That's fine. You want me to ask?
Here's the thing, ask Lori and Donna, because I know with Donna's, what we said here is exactly what they did to her house. With regard to a kitchen that hadn't been changed and her, the property value. So, and the street cards, Donna and Lori both from time to time went to the assessor's office numerous occasions, checking out people's street cards. And I never went to the assessor's office
that's fine.
checking it out, so.
In your report, the BA raised concerns about Mr. Helm's qualifications, correct?
Yes,
What were the concerns about his qualifications?
well, he said he was an appraiser, licensed appraiser, and he's not. He also claimed that since he ran a landscaping company, that's the equivalent of being a soil scientist. And so he I already went through how he changed the land classifications.
Did he ever, but did he ever actually state in a meeting with you or in anything in writing that because he ran a landscaping business,
Yeah.
that he was the equivalent of a soil
Yes,
scientist?
that's what he said. It's almost like a guy that says, well, I stayed at Holiday Inn Express last night, so I can run a grain operation. The guy actually said that when Lori said, are you a soil scientist? And he said, no, but I ran a landscaping company for 32 years or whatever it was. So.
All right, so
yeah,
it's fair to
did
say he
that.
didn't say he was a soil scientist, but when he was asked about whether he was a soil scientist, his response was that he had experience in that area because of his landscaping business. Is that
And
a fair?
also,
Okay.
that he's the one that brought up soil scientists, because he was telling us that soil types in Connecticut, you go by the type of soil in terms of classification, not something else, whatever he was saying. And that's, he took talking about soil scientists and this. So Laurie then said, are you a soil scientist? And that's what his answer was. Also, I believe she has, and it's on one of our minutes, where it might be the July minutes, where he has his resume or his application to the town, where he stated on various times in jobs he's had, he's been an appraiser. And Lori, as an appraiser, commercial real estate, testifying in court and all that stuff, he's not a licensed appraiser in this or any other state that we're aware of.
My recollection was that he has these certifications to be an assessor. I don't, yeah, I don't remember. I'd have to go back and look to see if he's a. My recollection was he was not a commercial. He was not licensed as a commercial appraiser. That I know he was.
Yeah.
I do remember he was not an MAI, a Master of the Appraisal Institute.
Yeah, he's not licensed. What he did say to Lori when she said, "Are you a licensed appraiser?" He said, "Well, no, but I've taken all of the courses. I just haven't passed the test." So that was his response to that.
Was Della a licensed appraiser?
I don't know. She never said she was.
But you raised a concern about Todd's qualifications. Did you have similar concerns about Della's qualifications?
She never said I'm an appraiser. Not that I'm aware of. She never told us she was an appraiser. She's an assessor and she can give a value, and that's fine. When somebody says, in addition to being an assessor, I'm an appraiser, you know. So
So is
there's a big difference.
is it fair to say you're concerned about Todd's qualifications with regard to whether or not he was an appraiser was not whether or not he was a licensed appraiser, but rather that he represented that he was an appraiser and in fact didn't have the license? Is that your concern?
Well, I'm not sure he's qualified just because he says I took tests and all that. I don't know why he would say it. He didn't have to tout himself by or boost himself and telling you how great he is. He's the assessor. We would take what he said and put a value on it because he is the value his statement or his opinion because he's an assessor. Once he starts going to these other things, it just seems like if he's not truthful in one, is he truthful in all?
Did you have any other concerns about his qualifications?
Not that I can think of off the top of my head. I think I already told you about his statement about record keeping, where he basically, I thought he was saying he's not going to be good at keeping records, and that way you'll get rid of a lot of farmers from the 490, and that if you get rid of 100 farmers, only 50 will come back in, so you've effectively increased the grand list.
Did he state that to you guys in a meeting?
Similar words to at the meeting, but also he told Lori that when he was over her farm. She'll tell you that.
Okay, so in your report, did you state that Mr. Helms created a confrontational atmosphere?
Oh, yes. Yeah.
And why do
I
you
remember.
believe he created a confrontational atmosphere?
Why did he?
Why, in your opinion,
Oh.
do you believe he created a confrontational atmosphere?
Do you mean, what did he do that led me to conclude that? he
Yeah,
was
I mean, you
creating it?
made the statement that, or at least in the
Yeah.
report, there's a statement, I
Yeah.
believe that he created a confrontational atmosphere. Could
Okay.
you tell me why you reached that
Okay, no, I
conclusion?
think I understand. I thought you were asking me why in his head did he create it, but you're really asking me, how did I come to the conclusion that he created?
Just
it?
so you know, part of this process
Yeah.
is to give everybody an opportunity to explain their positions. And if
Yeah.
there's a position that you stated that's not abundantly clear as to how you got there,
Yeah.
then part of my job, I feel, is to give you an opportunity to clarify
Yeah.
why you got to that position.
Okay. Let me see.
You don't have to go crazy with the answer.
No,
I'm
no.
just trying to give you that opportunity.
Yes,
Well, why you believe he created a confrontational atmosphere.
okay,
This isn't a test. You don't have to,
no,
there's no right or wrong answer.
but let me see. Yeah, I
We'll
would say,
discuss scheduling when we get a chance. I don't know if you want to keep that on Zoom. I don't mind keeping it on Zoom. I just want to discuss scheduling because it's almost 1 o'clock.
I know.
You have somebody out in the hallway who I expect will want to discuss things thoroughly. So I'm going to propose that the third person be rescheduled for another day. He's going to be long as well.
Can we go off for a moment? If you don't mind with the record, can I just pause it so we can talk about scheduling? I just
Yeah.
don't want to. All right, we're back on record. Okay, so the last question I asked you before we took a break to talk about scheduling was why did you believe that you stated in your report that Mr. Helms created a confrontational atmosphere? Why did you reach that conclusion?
well, because first of all, when he posted on the outside of the doors without our knowledge or consent, was this notice which led people to believe that we were, the Board of Assessment Appeals was,
Oh, that's your exhibit. That's the exhibit
Yeah,
4 here, right?
yeah,
That's exhibit
yeah.
4. Okay, that's
okay, so,
hey, that's, by the way, that's exhibit for the record. That's exhibit 4 to the report that we're discussing right now, which
Correct.
was dated May 28th, 2022.
Yeah. so started off that way, and also when people were coming in, the people having them sign up that they were there from the tax assessor's office were explaining to them that the Board of Assessment Appeals is tape recording everybody this year. So I made the announcement to people, it's not the Board of Assessment Appeals that's tape recording, it's the tax assessor. Tax assessor sat in the room behind people, and he had his tape recorder going, and 2 other people from his office with their tape recorders going as we're doing the 3 hearings. And from time to time, I'm told by Lori and Donna, but I didn't see him do it, he would make faces. So if the taxpayer said something that Todd disagreed with, he would make some kind of a face mocking them or making fun of them or whatever. I did not see him do that. That's what I was told by them. And then during the hearings, he would from time to time get up, move around. He wouldn't go where I told him to go in terms of giving some degree of space with people to be like, at least I forgot what our rules say, maybe 10 or 15 feet away from them, so they don't feel like you're breathing down their neck. And just his overall demeanor and attitude. I got your book. This is the one that you gave me the exhibit in case you want it back.
Yeah, when I'm done, yeah, when you're done, you
Okay,
can leave
good.
it for now. That's
Okay.
fine. I just put a sticky note on there with
Yes.
an 8 because I
This is
keep,
all yours, so I don't get it mixed up. with
yeah,
any
that's
of mine.
fine. I just have a sticky note on it because I was trying to
Oh.
keep track numbers wise on my
Okay.
outline. That's all.
Yeah.
In case you're wondering why I was on there. So on page 5 of that report, you mentioned there's a 3-page questionnaire that was mailed to applicants.
Yes,
How did you know that the document was composed and mailed by Mr. Helms?
because we asked. I asked.
You
who
asked him?
mailed it. I asked Della. Not Della, I'm sorry, Vicky,
Okay, so Vicky confirmed for you that Todd sent that out.
correct.
Are you aware that the same document was mailed? I shouldn't say, are you aware? My understanding was that the same document was mailed to appellants in previous grand list years before Mr. Helms was hired. Were you aware of whether the document was sent in prior years prior to him being hired?
Well, first of all, it wasn't sent when I was chair. Secondly, this document that he sent is not the same one that was sent the year before, according to Donna. And for instance, one of the additions he put on here was list the names and addresses of any and all accounting firms and accountants employed by and or consulted by the appellant for purposes of financial record keeping. It's stuff like that that I thought was way overboard. And I didn't care what they did in prior years. I thought they should have let me know at least that they intended or would like to do it this year. He had a meeting with us and never told us he was sending these documents out. And I know the ones that he sent out were dated like March 30th. And again, the document itself starts off with Town of Enfield, Connecticut Board of Assessment Appeals. Basic guidelines for assessment. So it makes it look like we're the ones sending it out, which of course is not true. So we had some people that came in and one that gave me a copy of his what he got, including the letter, the envelope, and said that he was he thought we're the ones that were asking for all this information.
However, if a similar questionnaire was sent in so if a similar questionnaire was sent in prior years to appellants, did you in previous years have a concern that it was sent to appellants on behalf of the Board of Assessment Appeals?
I can't answer that question because I never saw it sent when I was chairman or before.
Okay.
And also this, remember, I know of at least that question that he added that I just told you about that I thought was really obnoxious. And I can't believe you're asking people who did they consult with about a financial circumstance. It's like asking somebody, how many lawyers you go to before you ended up with the one that gave you the answer you want? You know, I mean, it's just,
I understand
ridiculous.
your concern. All right, so is
so
it?
no, let me put
Yeah,
it this way.
sure.
If he wanted to send it out, I don't have a problem with him sending it out. But I think it's devious and deceptive to say, make it look like we're the ones that are sending it out.
So is it fair to say that so you have the 23 appeals coming up? Did
Yeah.
you, is it fair to say that on your list of items that you want to go over with him, that if this is gonna be sent out on behalf of the Board of Assessment Appeals, this questionnaire that you'd like to, I don't want to put words in your mouth, but sounds like from what you're saying, you think the board should have a say in, if it's gonna be represented as coming from the BAA, as to what the requests are?
Yeah, but I'm gonna talk to our other two members also and make sure that we have a consensus on it before I would tell them that. Basically, if it's up to me, I would say, you want to send it, go ahead, but send it under your own name, not under ours. Not under Board of Assessment Appeals. Tell them who you are. This is Todd Helms. I'm assessor for the town of Enfield. These are the things that I want you to bring in for your assessment appeal. I don't have a problem with him doing that. I just have a problem with him misleading people into thinking we're doing something then that we're not, whether it was tape recording or whether it was this letter.
With regard to open space, was there anything you wanted to address from that report with regard to open space?
Well, I think we pretty much put in some exhibits in there that clarify it, and fortunately, Lori, again, is the background with the open space that has all of that information, including more.
With regard to I want to talk to you about some specific appeals. So in general, I'm not going to ask you or anyone else in the BAA about all these decisions you made, because you know, whether it's irrelevant what I think about decisions I made. If I, you know, whether I was sitting here, if I was sitting in your shoes, what would I think? Who cares? It's irrelevant. I'm not on the BAA. There were some applications I wanted to ask about because I just didn't understand how you got to certain conclusions. Just a few that I wanted to ask about, and then just some in general. Because we've got the records, but again, not looking to go through all these decisions you made. So the one that I want to talk about was, it looks like, so Lori Longy had a few appeals. Do you mind if I take that back?
I was just going to
Thanks.
flip on and do.
So Lori Longy had a few appeals. Thank you. Okay, so the appeal I have here is from David and Lori Longy regarding 78 Park Avenue. Do you have a copy of that appeal?
I don't have it with me.
I should have brought it. Let me see if I should copy it. I'm gonna ask you about it. I think it's helpful for you to have it. Right with you. So this is the appeal. And if you could show that to your counsel as well, I'd appreciate it. If you want to make an additional copy, please feel free to do so. So, are you familiar with this appeal that was filed by David and Lori Longy regarding property at 78 Park Avenue?
Well, I've never seen this before. I don't think. A quick claim deed. dated after the appeal.
Let me see that.
How'd that get in here?
I don't know. Let me see.
It says June 15th, the appeals in March, it was decided in April
Yeah.
or May.
So,
So is somebody sliding in another deed there perhaps?
no, this is the appeal. That's the appeal.
Yep.
And then I must have gotten a copy. I got a copy of a deed, which would have been afterwards. So it's a deed.
Well, afterwards, then of course, that wasn't part of the appeal.
No, I understand. So I have some information about an application that was filed afterwards on, so that's all I'm asking about. So, the appeal is,
I'd like a copy of that, but if you don't mind, will you just,
yeah, it's fine.
okay, good.
And it's gonna be in the, also in the full record that we have.
Yeah, that's okay. Before you leave though, I'd like a copy. if you
That's
don't
fine.
mind.
So, let's see here. So this was an application filed by David and Lori Longy for 78 Park Avenue. Do you remember this appeal?
I do, yeah.
Okay. And if you look on the second page of the decision, it looks like, so Lori Longy recused herself, but Donna and you were the ones who voted.
I actually heard it.
What?
Just yes or no,
Oh,
because I'm getting ready to possibly object, so I just want
Okay.
you to answer his questions
Okay,
until I see
so
where he's going. Because we
I
do
heard
object to any
Yeah.
questions about the deliberative process, so I just want to make sure we don't go there.
if I could also tell him, this is only this part of it, but there was more papers.
That were
attached to
submitted?
it. Well, yeah, there's a lot of papers. David Longy brought in a whole bunch of papers, copies of other deeds, but not the one you got.
Okay.
And a written statement as well as his own statement.
Let me check.
Looks like you just got,
This part of that. I have,
This part,
I have whatever's in the
yeah.
records. Bear with me. Let me go off record for just a
Yeah.
moment, because I don't want to waste time on a tape.
Mario? You're muted.
I believe they can.
Well, I'm gonna stop you right there.
Yeah.
So I didn't realize that I was muted. But I
Oh.
think you were not. So when we went back on the recording, I was somehow muted. So I had asked you, I'm gonna ask you, go back and ask you some questions if that's okay.
Yeah.
All right, so with regard to this application, so what I started off with was that prior to the break, or I'm sorry, we took a break and your counsel had asked me where I was going with the discussion, questions about this application. And I had explained that I wanted to ask about the application and also about Miss Longy's recusal. And so that's what I'm asking about. And with regard to the application, this was an application filed by David Longy for property owned by David and Lori Longy, correct?
Yes,
And did you have any communications or discussions with Lori Longy once this application was filed and prior to the BAA considering it?
no,
And I know earlier I'd asked you about your relationship with Miss Longy and you stated that she was a friend. Is that correct?
yeah, I'd say a good friend. Yeah,
Okay.
not just a friend, but a good friend.
A good friend, and
I have
that,
a lot of good friends.
okay. And that at some point in time, many years ago, you had represented her on a zoning application. Inland wetlands application, I think is what you
Yeah,
said.
I think it was not even the application. I believe it was. She was in court already on an appeal from an order from inland wetlands or something like that. It was in the late 1990s or early 2000s.
And what is your relationship with Mr. Long, do you have a relationship with David Longy?
Well, only to, I know he's her husband and when we say hi, that's about it.
Is it, so the close personal relationship that you have with, that you've described as having with Miss Longy, do you have that type of relationship with David Longy?
No,
Have you ever represented David Longy?
no,
Did David Longy present the application to your board?
yes,
And you know what? Before I get there, before I go any further with the discussion before your board, so with regard to recusals, you decided not to recuse yourself for this application, correct?
correct,
And Ms. Dubanowski decided not to recuse herself, correct?
I guess. I mean, I never asked her if you're gonna recuse yourself.
But she
That
obviously,
didn't occur to me.
she heard it and
didn't.
voted on it, so she didn't recuse
Well,
herself
She
either.
didn't hear it. I was the only one that heard it. She was doing other ones at that time. So that
But she deliberated on it.
she participated, I explained to her and showed her the documents. And we deliberated and then we decided, but she did not hear it. initially.
Which is the normal course of business for a BAA where you have an individual member hearing it. An
Yeah,
application.
exactly,
Okay.
exactly.
So as far as the process there,
Yeah.
it was nothing different than
No,
what you've done with
no.
others.
No,
Okay, all right. So if you had recused yourself, then that would have only left one person on the BAA, which I don't think would have
Can't make a
allowed the BAA
decision.
to make a decision.
no quorum.
And so my understanding is the BA in 2022 did not have any alternates, correct?
Correct.
So had you recused yourself, this application would not have been able, the BA would not have been able to consider the application. Is that correct?
Yes,
So with regard to the application, my understanding is that Mr. Longy gave you substantial documentation in support of the appeal. Is that correct?
yes,
Looks like he gave records regarding the subject property, including a copy of a tax collector's deed. Is that correct?
among the documents, yes. A lot of documents, more than I actually remembered. I think there are about a dozen, looks to me like there's now 11 plus, well, about 23 pages worth.
And it looks like he also gave a copy of a record regarding 74 Park Avenue.
Yes,
So when he presented his appeal, do you remember what the reasons were for? Do you remember what his argument was in support of his appeal?
Well, I remember some, but I'm also looking at his statement that he read into the record, which is your Bates number 5995.
Mhm.
And
Yes.
so this is, yeah, that's, as I recall him, he actually just read it into the record, the whole statement.
And that statement is, has a Bates stamp number of what on the bottom right hand corner?
BAA-59995.
All right, so BAA 5995, is that
Yeah.
correct?
Yes,
And so first of all, in the statement, he provided that it was purchased at a tax auction.
Mhm.
And that in 2020 and 21, it was that he marketed the lot with another lot
Mhm.
down the street at 42 Park Avenue to several builders and developers, correct?
right,
And that there was an agreed upon price of 40,000 for each lot. But when in preparing to sell the lots, and doing preliminary survey work, from what he wrote here, it looks like there was an issue, correct?
an issue as to the title because the property description was not that which matched 78 Park Avenue.
So as a result of this title issue,
Mhm.
in the document that he provided here, it looks like he's arguing the total value of the property as of October 1, 2021 is 0.
Yes,
And that after that, he wrote, the lot really has no value because it can't be sold. Correct?
mhm. Yes,
And that when the title is, and then later at the end, last paragraph, he puts, when the title issue gets straightened out, he thought the value of the lot would be 40,000, correct?
yes.
Do you know when when the BAA heard his application?
Yes. Hold on one second. Let's see. You know what, I don't have that in front of me. When we decided that was May 20th. So it was prior to May 20th that we heard it. I believe we had to hear them all in April, but I don't know the exact date it was heard. I don't see it anyplace here. Oh, wait, I do. Here it is. I have a form that we made up with regard to our own minutes. And it says April 20th on it.
All right, so that was April 20th,
So
correct?
on April 20th, yeah, David Lange appeared on joint property. I heard it. He initially had an estimated fair market value of 15,000. He then modified it to 0. 15,000 was on his initial appeal. And then he read and introduced into evidence a statement to document and substantiate his claim. And that there was a quiet title application. So that the property was not marketable. And he and she obtained it from a town foreclosure sale. And the deed that they had gotten, which he has in evidence, attached the wrong description for a different piece of property down the street.
So let's look at that deed.
Sure.
So the deed was. Is this the tax collector's deed you're referring to?
Yes,
And that's BA, Bates stamp BA 5999
Right.
and BA, through BA 6001, is that correct?
yes,
All right, and then after that, if you see those documents that he
Mhm.
submitted, Bates stamp BAA 6002.
Yeah.
Where it says, where he shows a 74 Park Avenue property, and then see where it says lot number 28.
Mhm.
The owner is Robert Brunk, correct?
yes,
Okay. And then after that, he's got a warranty deed, which is that looks like it was recorded in May 14, 2019. And that's Bates stamp BAA 6003, correct?
yes,
So. And it looks like the argument that he was making was that the property at the subject property at 78 Park Avenue had a title deficiency. And that title deficiency could only be resolved by having some sort of conveyance from the property at 74 Park Avenue from Robert Bunk. Does that,
Yes,
Seemed like what-
also when you were describing the deed, Robert Bunks, if you look at page 6005, that's the one with the Schedule A, which looks like it's the wrong description for 74. Now, it looked like somebody put a description out for 78 with 74 and 74 is with 78 at some point in time.
so after you heard, do you remember the hearing that took, do you have any recollection of the hearing that took place?
Yes,
Okay. Did you ask Mr. Longy questions?
yeah, I did.
Do you remember what questions, do you have a recollection of what you asked him and how he responded?
Pretty good. I have a pretty good recollection because it's unusual to have a board member who's taken an appeal that we're hearing. So,
But just to be clear, you didn't
Yeah.
have a board member taking an appeal.
no, well,
The appeal was
he owns the
taken,
property,
yeah, but the
Yeah.
appeal, just so I make sure we're
taken by
clarifying,
David.
just to be
That's
clear for
correct.
the record.
Yeah.
She was the property owner.
Yeah, she was a property owner jointly with him.
All right,
And
and
thank you for correcting that, because I didn't mean to
no, I understand.
misstate it.
I understand what you're saying,
Yeah.
but so it was obviously one that got your attention because she was a property owner. Okay, so
Yes.
tell me about the back and forth
Well,
during the meeting.
So I asked him, how we got this way and what efforts have been made to try and straighten it out. And what he told me was that the property was, transferred by the town of Enfield. I believe it was Della Froment that signed the deed. And it was Mark Serrato, town attorney's office, that prepared the deed. And it had the wrong description. And that they or he or she, I don't know which one, had made efforts through the town to get the town to correct it by a correcting deed. And that Mark Serrato was not going to do it. And I believe what they said was that he either didn't know how to do it or he wasn't going to do it. So that was it. So basically, they took a piece of property they got from the town that had created the deed with the wrong description, gave it to a layperson. I understand also they were not represented by anybody. I know I didn't represent them, and I don't believe they had anybody representing them when they bought this. And so I think the town attorney had had an obligation to deal fairly and honestly with them. I believe he probably did, and I don't think Mark knew at the time he was doing it that he was pointing off a deed with the wrong description. But he certainly knew at some point after that, and was the town was not about to do anything to correct the situation. And I know also that they said that they had either been to or were going to ZBA requesting a variance. They had to go to planning and zoning for a special use permit or some kind of special permission anyway. I'm not sure exactly what. And that throughout this period, I didn't represent, nor anybody in our firm represent Lori or David in buying it and discussing it and trying to get it back to a correcting deed situation or whatever. And I know that she had been to a couple of lawyers and I believe ended up at Despina Tartsinas, who was the one that was representing her in selling to the new buyer when all of this happened. And so in my view, with everything that was said and what I knew, I thought it was the town that either made this unmarketable or refused to cooperate in making it in removing the impediment so that it would be marketable. And that so under those circumstances, I didn't think it had a value on it that the town should be collecting taxes on. Part of my basis for that also is I gave you back the stipulated judgment from Post Office Road. And in that, that was a situation where the town was responsible for making property unbuildable that I had intimate knowledge of as one of the attorneys representing my wife, along with John Droney, Kathy Elderville, and so on. And
So
so,
just to clarify for the record,
Yeah.
are you referring to a case titled Maryland Tyler versus the town of
Yes.
Enfield?
yes,
And are you referring to a stipulated judgment that you provided me a copy
Yes.
of earlier this interview?
Correct.
Which was dated October 7, 2016,
yes.
and
And
it was,
It's recorded on the land records also. And in that I highlighted in yellow for you, so you don't have to go too crazy reading it, but I hope you do. But instead of reading the whole thing, the town did agree that from 2006 to 2016, which was the period it was unmarketable and unbuildable because of what the town had done, that they should pay back the taxes that Maryland had paid. Taxes she paid was $99,000. As part of the stipulated judgment, the taxes came back, which to me meant that they shouldn't have been taxing anything when they in fact participated in either making it this way or failing to correct it. On that, I'm just saying, my framework in my head is then thinking that. Although I made sure I did write in here, because they said I know they were trying to clear the title, and I know they were, going to various boards to get it approved. And so that's why I wrote down here on my Bates number 5988, that there's no clear title to the property bought from the town of Enfield, property not marketable, fair market value not more than 40,000 if it becomes marketable, and taking into account everything that that David Lange had presented me with.
so is it fair to say that it was your position that once, first of all, that, you accepted Mr. Longy's argument that the value of the property, if it had marketable title, would be no more than 40,000.
Correct.
And second of all, that it was your position that as of the date that you heard this, which was April 20th
Yeah.
of 2022, that that it was your belief that it was not marketable. Is that correct?
Correct.
And that if at some time in the future, they were able to, the owners were able to resolve the title issue, that then the value would be more than zero. Is that correct?
Yes.
And was it your position then that if the title issue got resolved, that the assessor's value should go up on the next grand list?
I think once they had the title situation clarified, then I think that they could, no, actually, not even the next one. I think actually they could take it from the day it became marketable, and then use that date and give them an interim assessment bill.
So is your position that once the marketability issue or title issue got
Yeah.
resolved, that as of that date, the assessor should have the right to, in his watchtower role, as of that date, change the valuation to reflect that it now had marketable title?
Yeah. Yes.
And if he was to do that, is it fair to say that based on what you've stated here, that based on what your notes are in the decision, that the value should be no more than 40,000 and not what the number that the assessor previously had?
Correct. There was one of the problem with this property, now that I think about it, there was, I believe they had a shed on it. And I remember asking David, do you like rent it? Do you use it? Do you put anything in it? I'm trying to figure out,
Yeah.
is there a value? And they don't use it, it's dilapidated, and in order, I know in Enfield, in order to take out a building permit, if you got a shed on this property, it's dilapidated, you gotta remove it before you can get your building permit issued. So in effect, this had a negative net worth, but I wasn't going that far.
Is it fair to say, though, that even if they didn't have marketable title,
Mhm.
that there could have been some use for the property? For example, they could have stored something on it. Some minimal use without marketable title.
I suppose.
And so, and for example, you would need marketable title presumably to sell the property, correct?
Yes. Or to
And
do anything with it that's, now, they'd have to then figure out in a residential zone, I guess, what uses are permissible in that zone, short of having a residence on there. I don't know the answer to that. It
Yeah.
depends on, and what the the zoning ordinance says.
That's a fair point.
Yeah.
You're limited as to what you
Yeah,
say. You
it's-
can't
I
just
mean-
assume you could do anything, right?
No, it's, yeah,
So, and I'm not suggesting that
Yeah.
you should have been obligated to do this,
Yeah.
but did you accept the applicant's word on this as to the issues of the title issues? For example, did you do any of your own independent research
no,
with the town clerk?
no. I used the deeds that they gave us,
So you relied upon the deeds that were provided to you by
Yes.
the applicant?
correct?
For example, you didn't call the attorney for your title company and say, what do you think about this, right?
No.
Okay. So I think you said that at the time that you were aware of the fact that the applicant wanted to go forward with getting a special permit approval and a ZBA and a variance, okay?
Yeah.
And did you know that at the time that the applicant applied? Or at the time you heard the application
I didn't know it until I believe it was told to me at the time.
at the application hearing
Yeah.
or afterwards?
No, well, I don't know what, I believe David told me that when he was there on April the 20th.
Okay, so at that point, he had told you that he had plans to go
Yeah,
forward
I
with
don't
getting,
think they had submitted any, although they might have, I don't know, but that was the plan in order to do anything with the property.
I wasn't suggesting
Okay.
written plans. I was saying that,
Okay.
is it fair to say that when he met with you, it's your recollection that he informed you that he had future plans to get zoning approvals for a building at the property?
Absolutely. In fact, they'd already had a buyer. I think they get the same buyer then that they had that led to this whole thing. So I don't know what's happened after that, other than supposedly they got approval.
My recollection,
Yeah.
they didn't have approval at the time you heard.
No,
the-
no, no.
And my
They got
rec,
approval afterwards.
we'll get to that. And my recollection from what I read here
Yeah.
that he submitted was that I think he had a contract for 40,000 for this lot.
Yeah.
Is that correct?
Yeah.
Okay. So, and that's why, and is that why, so he had he represented that he was going to sell for 40,000. Is that why you believe the value was around 40,000?
Well, that and all the other things, that he had in here.
Did that have impact, did that impact your thought process? If they were selling it for 40, that it was probably worth no more than that?
Yeah, because third owner is an appraiser that knows property values. So does David, who's married to her. They got a piece of property and that they put out for the market and they come up with a buyer. I'm assuming it's fair market value. They're not trying to sell it for less than what it's worth.
Fair assumption.
So,
So, I have a copy of a statutory form quitclaim deed. I'm gonna show this to you, which was from Robert Brunk of Enfield for consideration of $1 to Lori and David Long. Please take a look at that. I also ask you to show that to your counsel. I'd also ask that you take a look at the BA application and the BA bait stamp. Page number. $5,995. As well as give you the other page. BAA 6002 and 6003. So if you look at those 3 pages, one of them is his summary of his argument. Which indicates that that the legal description that the town provided with the deed was deficient for 78 for the subject property at 78 Park Avenue. And that in fact, what the town had actually gave him was a legal description for 74 Park Avenue, which was the house down the street,
yes,
that was owned by Mr. Bunk.
yeah,
Okay. And that, and then he goes on to say that he hired a lawyer in May of 21 to try to straighten this legal issue out. Okay. And so do you see the deed that I just provided you a copy of,
yes.
which is
The
from,
one from Brunk to David and Lori Lange.
all right, does that appear to be a deed from Mr. Brunk to David and Lori Longy? Quit claiming them, the title, the proper title to 78, Park Avenue?
Well, it's a quitclaim deed apparently to try and straighten out for 78. But the parcel they mention is lot number 28. But I think there's a difference between the map that's on file perhaps, and oh, there it goes, okay. And what the, what the street number is, and that's not unusual either. You have a different lot number than a street number, but. So it's 78, so, okay,
So, and and by the way, I know you're not I'm not expecting you to be a
Yeah.
title expert, and quite frankly, you're looking at this just like I am. So does it appear to you, maybe if it's helpful to you, it appeared to me that this is a deed which was provided to the Longies in order to resolve the title issue with Mr. Brunk's property. That's what I assumed
yeah,
it
I'm wondering
was.
if there was another one back of this or in front of this from the Langes to this guy.
I don't know.
Yeah, so,
That's a good question, but
yeah.
but the bottom line is, if you look at that, it says it was, if you look at this next page of that document,
Mhm.
it was dated on what date?
Signed April 3rd.
All right, so it looks like that he provided it to them on April 3rd of 2022, correct?
No,
What's the
it's
date?
just that he signed it on April 3rd. That doesn't mean he provided it to them.
Fair enough.
So
So,
he signed it and his lawyers swore him in on it. And then it was recorded in June, but.
well, actually, no, that's not the recording date. If you look at
Oh,
so let's just make sure we're clear for the record. So it looks like, all
oh, I see. Okay, I'm sorry, yeah.
right, so you're
Yeah.
correct. that
Recorded April 21st.
we don't know if it was provided
Yeah.
to Longies.
Yeah.
On April, what's the date that it was recorded? Not recorded, I'm sorry, I retract that question.
Yeah.
What was the date that the statutory form quitclaim deed that you have before you? What was the date that it was signed by the grantor?
It says it's April the 3rd. And sworn in on April 3rd also, so the deed is fully completed apparently, and it looks like a legitimate deed on April the 3rd, 2022.
And it was notarized as well, correct?
That's when you were
So
sworn in.
April 3rd, 2022, it appears that the grantor had executed the deed, correct?
Yes,
At some point, the grantor gave the deed to David and Lori Longy on April 3rd or some later date, correct?
or the attorneys, yeah.
Fair enough.
Assuming
Some-
they've
at
got
some point,
lawyers
fair
that are
enough.
doing it, Yeah.
Then it was recorded on the land records, it looks like by David and Lori Longy, correct?
Yeah.
Or someone on their behalf.
Yeah, on April 21st.
And what was the time on April 21st?
10 o'clock in the morning.
All right, so at 10 a.m.
Yeah.
on April 21st,
Yeah.
that deed, which possibly could have resolved the title issue, was recorded, correct?
I would say that deed that did resolve the title issue.
So now you met with David Longy the day before for his BAA hearing.
This hearing was April 20th, right?
When he met with you
Yeah.
on April, and by the way,
Yeah.
you're not an investigator,
Yeah.
you're a Board of Assessment Appeals
Yeah.
member, so you don't have an obligation to interrogate people. People provide you things, you assume that. When he came to you on April 20th, the day before, did he inform you that he was in the process of or had obtained a deed to resolve the title issue?
No, he didn't say that he was had obtained a deed or anything like that. He did say they had a lawyer that was trying to work it out. And I believe the lawyer, well, I'm sure the lawyer he sent was Despina Tartsinas that was working out for him.
I believe it's also was in his application that he retained counsel.
Yeah.
If Mr. Longy had told you
Mhm.
on April 20th.
it wouldn't have been too late in the evening. If we started at 3 or 4, we wouldn't have gone maybe 7 or 8.
All right,
So
but presumably it would have been at the end of the day. Either late afternoon.
I
or
don't
evening.
remember exactly what time, but it was that day.
All right, so, but you didn't usually you met after 3 o'clock, right?
Yes,
So when you met with him on May 20th.
Yeah.
Later in the day,
Yeah.
some point after 3 o'clock.
Yeah.
If he had told you that he was in the process of obtaining or had obtained a deed to resolve the issue and he was going to return it, he was going to file it on the land records the very next morning.
Yeah.
If I could just finish my question.
Yeah.
Would you have made a different decision?
I have to think about, let me think for a second on that.
Take as much time
And
as you
first
want.
of all, I never saw this deed until today.
I know.
Okay, no, well, you don't know that, because
Oh, no, that's fair.
maybe
point.
somebody showed me, but I mean,
Yeah.
no, I didn't know that. I did know afterwards that they had resolved it, but I didn't know when. But in my opinion, my decision probably would have still been the same. I don't know about after I talked with Donna, because we're looking at the grand list as of October 1st, 2021. However, I do think that armed with this, the tax assessor could issue another interim bill from the date of probably the date of the deed rather than even the date of the recording, but I'm not up on that. But that's all it would have been. I mean, we're asked, he's taken an appeal as of October 1st, 2021. So as of October 1st, 2021, this is the status of everything. This isn't until April. But again, I think that the tax assessor could adjust it as of the date that it was corrected.
Do you think that Mr. Longy, when he was before
Yeah.
you, late in the day or evening on on May 20th, in order to be fair to the Board of Assessment Appeals, should have informed you that he had the title issue resolved and was going to have a deed recorded the very
If he
next
knew.
morning?
If he knew, I mean,
If,
I don't
okay,
know.
let's assume Mr. Longy
Yeah.
knew.
Yeah.
That the title issue was resolved, that they had a deed in hand.
Yeah.
And that it was going to be recorded the very next
Yeah.
morning. Do you think that he should have informed you?
Not only should have, I think he would have. So you got to talk to David Longy to see what he knew and when. But I find it hard to believe he'd come, give us this story as of October 1st, and then have a deed and not record it purposely until after the hearing. And the other part of this, of course, is that even after the hearing, we didn't know it was recorded. We didn't make a decision for another month.
I understand.
So I mean, so when we make our decision, I'm not aware of it then either.
I understand that.
But even then, yeah, so go ahead.
Let's assume a month later, you knew that the deed was recorded. Let's
Yeah.
assume you happen
Yeah.
to know.
Yeah.
If you knew that.
Yeah.
Would you have made the same decision?
Yes, but I would have told the assessor, you got a deed now. If this thing has all been resolved, so what you should do is go and issue them an interim tax bill, much like you do when you have a piece of property with a building permit. You got a building permit issued on a piece of property, well, it's taxed as assessed as vacant property, vacant land, whatever. But then once the CO is issued, then they issue an interim bill.
And I believe you're referring to the assessor's authority under Connecticut General Statute 12-53A. Is that correct?
I don't know the statute.
Okay.
You know better than I just know what he can do.
Assuming I'm correct, that it's
Yeah.
connect, but under Connecticut General Statute 12-53A,
Yeah.
it allows the assessor to increase the value on an interim basis
Mhm.
as of the date of a certificate of occupancy or as of the date for which the property was being used for the purpose for which it was constructed,
Okay.
if a CO
Yeah.
wasn't
Yeah.
in
Got
fact
it.
given yet.
Mm.
But here that wasn't the case because there was no new construction. The change would have been with
Yeah.
regard to the change in status of the title, correct?
Yes,
So I don't know if under the assessor's watchtower role, and I think that's Connecticut General Statute 1255, if you would actually have a legal right to, as of the date of that
Yeah.
recording, then change the title. But Rich, you can make a copy of that too, by the way. I didn't bring an extra copy.
Oh, we
Oh, this.
copies floating around.
He's looking
No,
at,
I'm talking about the deed, if you want to make a
Oh,
copy.
that's over
Oh,
here?
yeah.
No, the one that I just provided him a
this
copy
is
of.
it.
Yeah,
Okay, yeah, that one, I'm
So,
sorry.
yeah.
If you want that,
Yeah.
you can.
yeah,
make a
no, I'm
copy.
looking at the land records right now,
Um,
so.
So it's fair to say that if you had known about it, when you made your decision a month later, your decision would have been to lower the value to 0 from October 1 to the date of the recording, which I believe was April 21st.
Actually, I'm not so sure about date of the recording as opposed to date of the deed. You know, what I mean, so I would have told the assessor, hey, this is what's happened, and so issue an interim. Now, if the assessor then says I can't issue an interim, then it's a different issue, and he'd go to the town attorney and get an opinion as to
But
what to do.
let's
But,
assume the statute doesn't give him the authority to do
Yeah.
an interim
Yeah.
change
okay.
based on the type marketability,
Okay.
and you knew that, then would you have?
No, because the appeal is based upon what is it as of October 1st, 2021.
Fair point.
So as of 2021, this deed doesn't exist. The rest of the stuff does exist, including ZBA, P&Z, lost the buyer, all of that stuff. So, no, I'm going by what they're appealing as a back grand list.
And I'm almost done with this
Mhm.
application. I think you said you don't believe that when Mr. Longy came before you that he would have known about the deed. Let's assume he did, and let's assume that if I talk to him, he admits.
If he
if
knew,
he admit-
he would have.
Let me just finish the question. Look, just finish the question.
Yeah.
Hypothetically, let's assume I talked to him and
Yeah.
and right, or better yet, I
Yeah.
talked to his lawyer and his lawyer confirms, yes, he knew about it. I emailed him a copy a week
Yeah.
before.
Yeah.
If Mr. Longy knew that he had the title issue resolved and had that deed in hand.
Yeah.
Would you?
Is that to the other people?
Do you believe that he should have, at that point, he should have told you? If he had known?
Well, I would hope he would have told me everything, you know, I mean, the full candor and let me know what the whole situation is.
So therefore, if he had that issue resolved on April 20th, when he
Yeah.
met with you, do you think he
Yeah.
should have told you?
I think he would have told me.
I'm not asking if he would have, I'm
Oh.
saying, if he did know, do you think he should have told you?
Of course.
Okay.
You know, I think it's in all candor. Yeah, definitely. But I think if you're trying to imply, maybe I'm mistaken, is that something nefarious is, and they held this deed until the day after they had the hearing. Well, then they gotta be pretty stupid because the decision's not made yet. So why wouldn't they just hold the deed until after the decision's made back in May and then go file it? I mean, to me, it looks like it's just circumstances happened that, you know, it just happened, but it would not have made a difference on my posture. I have to ask if it might have made a difference on Donna. I don't know. She didn't hear all of this. You know, I just explained it to her. But again, this appeal is for October 1st, 2021. It's not for April 20th, 2021,
I'm
or
not,
2022.
and for the record, I'm not
Yeah.
suggesting anything nefarious, but again, I'm looking at the application.
Yeah.
Check the title with
Yeah.
regard to conveyances
Mhm.
and got a copy of the deed.
Yeah.
And I have not confirmed with title council
Yeah.
or done a title search that this resolved a title issue. I'm assuming it did. Because then it looks like on June 15th, 2022, this a few months later, they filed an application was filed to zoning with regard to the subject property. And that was after your hearing and that was after your decision. So presumably the issue was resolved, but I don't know for sure.
Okay, but maybe I'm missing with her. I don't understand. What's the purpose of this? So the guy's gonna apply for. I may be thick. I don't understand what. what's
Just the point is that
significance?
thereafter. they
Oh, I
applied
see,
to
okay,
zoning.
okay.
So presumably,
It cleared up the title issues, made it marketable, therefore you can apply and go in and get your. For the variance as well as the special use.
yeah, and
permit.
I don't know
Yeah,
for a fact if that's what happened, I'm assuming.
Yeah, I
So-
would say that makes sense.
That's all I'm saying. I'm just trying to
Yeah.
finish this so we can
Yeah.
move on. And lastly, I want you to look at this application. It looks like they applied for a duplex with 2,054 square feet. That's what it looks like was applied to zoning. So you had told me that during the hearing, Mr. Longy had informed you that if he was able to resolve the title issue, that he was gonna apply to zoning for some building on the property. Do you remember what he said he was gonna
No.
apply for?
No.
Okay. I was just gonna
No.
ask, is it with whatever he told you he was gonna apply for, was it consistent with what he actually applied for a few months later? But if you don't remember what he
I
said,
really don't remember when, I just know that they had to go to zoning and ZBA for the deal that they had with this expected, with this buyer.
oh,
That's the same buyer that they had to deal with, that all of a sudden, now they find out wrong property description, they'll straighten that out before you follow through on the rest of your deal. So I think the deal started, whenever it started, like 2021 sometime, and then went through, and then finally when they got marketability restored, now they could go ahead and apply for the rest of the stuff. I think how it came to them was through their, either there or the buyer's engineer.
Okay.
Who had come up with, there's a problem with the title.
um,
And this is what he wants you to make copies.
Yeah.
Yeah, whenever.
But right now, so don't forget.
While we're waiting for Rachel, I can still want to recite here that. I know you.
we're
covered-
still on record.
Yeah, I know. No, that's, I wanted on record. That, you know, about not recusing myself. I would not have recused myself even if we had. Other people involved, because I don't have any interest in this property. And my relationship with her is not such that it would. Deter me from being able to give a fair hearing. To her, so I would not have recused myself anyway, unless somebody asked me to. Now, if the town said, hey, you know, you're buddies with her, you should recuse yourself. Then I probably would have. Because it's another member that they're asking, okay, so recuse, but before you do. Now where are we?
So is it fair to say
Yeah.
that?
I don't have a conflict of interest with it. So,
Do you think you'd have an appearance of conflict of interest?
no. I did not represent, I'm taking a little note, just so you know, I didn't represent. Them when they bought it from the town, I didn't represent them when they had any aspect of negotiations with the buyer, I didn't have any representation of anything in terms of trying to straighten out the problem. And I didn't have any representation, to my knowledge, of this other guy. I mean, maybe our office represented him at some point, but I have no clue. Never heard of the guy before, David Brunk. But and then I think after this came out, I do remember now, I did call the title company and said, geez, I got an interesting one here. What do you do with this? Because it seemed like just a correcting deed. You know, if the two people did correcting deeds, that would resolve it. And I believe that's the answer I got is, yeah, you just do a correcting deeds, which looks like what they eventually did. But I didn't share that with anybody. I was just good for my own information.
So when did you contact the title
Oh, it
company?
would have been after the hearing with David. And it would have been before we made a decision in
So-
terms of, you know, just a correcting deeds.
So did you contact your attorney at the title company to inquire about whether if there was an issue like this, you know, how would it be resolved?
Yeah, it was generic. Well, I thought that the answer is correcting deeds from both sides. But I believe Brunk might have had an additional problem because if he had a mortgage on his property, now you can't just go out giving deeds to your property
Yes.
without getting prior consent of the bank. So, and then you say, well, what's the bank got for its mortgage? I mean, its paperwork, does it have the right property or the wrong one? But I didn't go down any of that path. I just simply asked the title company, if you got a situation where you had the wrong property descriptions on changes to correcting deeds, and the answer was yes. Correcting deeds back, in which is, looks like what they did.
I don't know if they, if the Longies did a correcting deed with Bronk. I'd have to look, did you check? Okay. Can we go off for one moment? I just
Yeah.
want to look at my records.
For good reason.
All right, Mr. Tyler,
Yeah.
we're almost
Yeah.
done here. So. I want to, are you familiar with an application or applications filed by the Jarmock? The Jarmocks, the Jarmock family regarding land lease for the placement of solar panels?
Yes,
And did you hear that application?
yes,
And did you reduce the value on that application?
yeah, when you say that application, just for my purposes, it was appeal number 307, 308, and 309.
Thank
They
you.
were all the solar, I don't have the base numbers.
Okay, and so what were the properties that were the subject of those appeals? I see that.
Yes,
It's easier if I read it to you. I can take the whole packet.
I think this is,
So what I have is appeal 307, 308, and 309, and that was made by Owen, by the property owner was Jarmock Farms LLC and Jarmock Real Estate LLC. And the owner's name was Owen Jarmock. And it looks like it was prop appeals. Looks like 307 was for Broadbrook Road. I'm sorry, 307 was for 65 Broadbrook Road. 308 was for sorry, 307 was for 65 Broadbrook Road. It looks like 308 was for. It doesn't give, it just says Broadbrook Road and gives an assessor's map lot 102 dash or slash 0050. And then 309 was for Broadbrook Road. Looks like 0 Broadbrook Road. And it was map and lot number 108 slash dash 06. And my so it looks as if the total value of the land and buildings were reduced on each of these applications to 0. Is that correct?
yes,
Let me give you these back. And so at the time that you considered these applications, did you know whether or not the town had a tax stabilization agreement
yes,
with the property owner?
yes.
What was your knowledge of that agreement?
With each of these applications, you probably didn't notice, but there's a copy of the sticky that Todd put on.
Can I see that, please?
Sure.
So the assessor put a sticky note on, for example, Appeal 307 that said, no new or amended application for PA 490, solar farm lease attached. So it looks like the assessor gave you, for your reference, a copy of the solar farm lease. Is that correct?
He gave us 2 pages, yeah, but it wasn't a lease. He had mischaracterized what it was, I think, because he didn't know.
What was it?
Well, I'll show you. Well, let me finish with this part first, because there's one more,
Sure.
or 2 more. This is the sticky you put on 308, which is a little different than the sticky you put on 307. But basically same, tell us it's a solar farm,
Okay.
okay? And then on 309, same thing, just puts a sticky.
Yeah.
Solar farm.
Okay.
So now, here then is what he gives us and says it's a copy of the lease. Gives these 2 pages.
So this was a lease for the solar farm, correct?
Well, that's not the lease, but it's, he says it's a lease, but be that as it may. What he had he was giving it to us in claiming that the stabilization agreement was going to take place and start later than
Well-
what it actually did start.
Well, this document you provided me says generation commencement date notice, and it provides a pursuant to the lease.
Yeah.
This notice shall serve as the generation commencement date, which is hereby declared to be
Yeah.
December 7th, 2020. So it appears from this document that there was a lease for a solar farm on the property.
Of course, town of Enfield's not a party to that.
No,
That lease. No,
it does
that's
not
between
appear.
The solar people and Garmark, whatever they want to do. So Todd's claim, and we did get a copy of the property tax stabilization agreement
Can I see
from the
that?
town, yeah. Now, I don't believe Todd didn't give us that. The prior year, Della had given that to the board at the time, saying you can't touch these properties because they got the stabilization agreement. So leave it alone. That's my understanding, and you can ask Donna because she's the one that was chair at the time. And they got the agreement. I don't believe this came from Todd.
The document you're providing me is
Yeah.
the property tax
Yeah.
stabilization agreement
Yeah.
dated February 3rd, 2020.
Yeah.
And Matt, for the record, we have a copy of this already, correct?
Correct.
You do, because we put it in the record.
Okay, yeah,
Yeah.
I know I had that,
Yeah.
and but pursuant to this document, it
Mhm.
provides that if you look at page 4, section 4 that you
Mm-hmm. Yes.
circled,
Right.
why don't you just
Mhm.
read for me the first sentence, please?
Project taxes shall be considered real and personal property imposed and collected by the town on the property. Semicolon. Shall represent the sole property tax payments to be paid by nutmeg to the town with respect to the property. Semicolon, and shall be accepted by the town in full satisfaction of any property taxes due on the property, period.
So based on this, and did you have an opportunity to review that property stabilization agreement prior to rendering your decision on that, on these appeals?
Yes,
So based on this, based on the tax stabilization agreement, that appears to be dated February 14, 2020, or I'm sorry, February 3rd, 2020.
Yeah.
Wasn't the property taxable?
well. The property is taxable and the stabilization agreement states the taxes to be paid, when it's to be paid. It started July 1st, 2021. So unless there's a change in the fair market value increased proportionately, then that's it. And so any real estate or personal property taxes are to be accepted by the town in full satisfaction of any property taxes due on the property.
As a
That's
result,
what our reading is.
but as a result of your decisions
Yeah.
in the 3 applications, 307, 308, and 309, the assessment for those 3 properties was brought down to 0. Is that correct?
Because of the tax stabilization agreement, that is what we were bound by.
So was it so by making that decision, taking the property values down to 0, was it your expectation that the town was still, or that the town was still going to get tax payments which were required under the tax stabilization agreement?
Yes,
So would if the property, if the property owner or lessee, anyone involved with the agreement with the town, argued that they were no longer required to pay the town the payments provided in the tax stabilization agreement because the BAA reduced the assessments to 0. Would you disagree with that position?
we didn't reduce their assessments to 0. We just followed what it said in the stabilization agreement with the section that you just had me read. So the nutmeg there is paying the taxes that are due on this property. Their taxes are based upon a fair market value of 21,300,000. If there's been an increase because of something that's built there or whatever, then that's up to the town and nutmeg to work it out and make adjustments for some changes that are made there, but that's not up to us to do that. And we are bound by the tax stabilization agreement from what it says insofar as our reading is concerned. We're not reducing the taxes on it. What we're doing is actually putting full force and effect on the tax stabilization agreement. And we do know that we've heard from Todd and others that in fact, there is no tax stabilization agreement on Jarmark. That's what they've told people.
So let me ask you,
Yeah.
so that agreement that's before you.
Yeah.
You have that in front of you?
Yeah.
Who's the agreement between?
The agreement is between the town and Nutmeg on these properties.
When you say on the properties, is it on
Yeah.
the structures or on the?
It's
land?
on the entire property, real estate, personal property, all of it.
I see
That's
that.
why with the stickies that say this is a solar property, we agree it's a solar property. And this limits what the town can do.
I see that again, if you don't mind. Document.
Yeah, it's just put down as the lease, so you're gonna go to the next couple pages.
If you look at page 3 of this stabilization agreement, which is dated February 3, 2020. If you look at where it says the definition of property, it says property means all real property that is owned by Nutmeg and identified on Exhibit A as property subject to the options to purchase. And then you look at Exhibit A, and it provides the lots that are subject to purchase. And you can look at the appeals, if I could see the appeals that are in front of you for 307, 308, and 309, please. I'm just trying to help expedite this a little. I'm gonna ask you some questions. So one of the appeal 307 was for street address 65 Broadbrook, which is map 102 and lot 48 and 10248 is a property subject to ground lease, but it was not subject to options to purchase. And then if you look at, it's confusing. If you look at 308, 308 is 308 is Assessor's map 102 lot 50. It's one of the properties that's subject to a ground lease, but it's not a property subject to the options to purchase. And then 309 appears is lot 108. Map is map number 108 and lot number 6 over here, and that's the property that's subject to the ground leases, but it's not the property subject to be purchased. So again, if you look at the definition of property, yeah, I'm gonna provide them to him right now.
You need to make a copy.
Yeah, there, yes.
This is the stabilization agreement.
You have that in front of you?
Well,
I'm gonna give,
that's not marked though. I don't think.
I'm gonna give this back to you, but if you have. If you, I'd ask you to look at this with your counsel.
But you know, I'm better off giving you this one, because this one is marked up.
Yeah.
Including where the assessor says it's all solar farm.
So I'm just gonna show you, if you look at. Page 3 of the agreement, it's clipped, so it keeps coming undone. See where it says definition of property? This is the front 3 pages, so you don't wanna. See where it says definition of property? Could you read that for me?
Where,
Where does it say definition of property? Oh, up here.
Either one of you can
Property.
read it, I don't care, whoever wants to read it. Why don't you have
Okay,
Mr. Tyler
well-
read it? If you don't mind.
well, why
What
does
difference
he
does it
have to
make?
read it?
Well, I was just
Yeah.
trying to explain it. So what I'm just
Yeah.
explaining to you is that
Okay.
if you
Oh,
look,
you didn't mean out loud, you just mean go over.
well, I could read it
Okay.
out. Basically, if you look at right here, I'm gonna stand up for a moment. If you look at where it says, I'm just trying to be helpful. If you look where it says definition of property, all real property that's owned by Nutmeg and identified on Exhibit A as property subject to the option to purchase. Okay, these are the properties that are subject to the option to purchase by Nutmeg. These are the ones that are the property that's within the agreement, that's subject to, that appears to be subject to this agreement. There's 3 additional properties that are not subject option to purchase, or rather are properties subject to a ground lease in favor of the Jarmox, which they retain ownership of. So, if you take a look at that, and I'm just gonna put this back here. My question was gonna be, does it appear that, and these are the three applications. If you look at the map lot number, I just read them to you before. Each of those map lot numbers that are on applications 307, 308, and 309 appear to be these 3, which are the properties subject to the ground lease, and not any of these properties. So my question then becomes to the significance of this.
Yeah.
If in fact, the 3 properties that are applications 307, 308, and 309 are not any of the properties that are within the definition of the property that's subject to the tax stabilization agreement, then isn't it the case that the tax stabilization agreement did not apply to those 3 properties?
That's a
that-
very complicated legal question that's beyond what we're capable of doing, but. Why did the guy then put down solar farm for each of these? Each of these properties, you just went through all this time and it's not this, it's not that. Why did he put down solar farm?
Because I can't speak for the assessor, but
Well, here's the thing, here's the deal. He put down solar farm. We believe it's a solar farm. Jarmark thinks it's a solar farm. The town says it's a solar farm, and the stabilization agreement, irrespective of what you describe in all property, anything else, Section 4 characterization says that all the payments made by Nutmeg with respect to the property shall be accepted by the town in full satisfaction of any property taxes due on the property.
what property?
The whole property.
The property is defined within, isn't it the property that's defined within the definition section of the agreement?
So what is,
I mean, yeah.
wait. So what is the purpose of these questions again? Is it a conflict of interest?
No,
Or
not at all.
something
I
you did
mean,
wrong?
no, I mean, no, it
Is
doesn't.
just like a light discussion about why he made certain decisions or
Fair enough.
intellectual exercise
I
about what
didn't-
property means? or
I
what?
didn't ask you about any conflicts with the Jarmox. I assume, obviously, you didn't recuse yourself, so I assume you had no conflict with the Jarmox.
Well,
They
wait,
should have
wait,
asked me to recuse.
we're just trying to
Yeah.
figure out what the questions are
Yeah,
about. I mean, I could see why you might want to ask about a conflict.
The reason-
there.
I wasn't planning on asking about a conflict because
Okay,
you
so
didn't
what
recuse
is
yourself.
the issue?
My question is, with regard to the BAA's decision here. My understanding is that from questions I asked you that you voted to exempt, to give to take the property value down to 0 for applications 307, 308, and 309. Because you believe that the tax stabilization agreement applied to those properties. Is that correct?
Absolutely.
Okay,
Okay.
so
Yeah.
that's good.
So what I was asking is, if you take a look at the tax stabilization agreement and you look at the definition of property,
No, we're not gonna do that. He already answered why he did what he did. You can certainly look at it, you can argue that it wasn't right or this or that, but he's not gonna be interrogated about it to say.
No, I'm not
I gotta tell you the other thing too, is that I wrote a very extensive thing here about pursuant to the terms and conditions, bang, bang, bang. And I pointed out to page 4, section 4, real estate taxes on this property are due from Nutmeg, not the appellant. The town agreed, quote, property tax payments encompass any property taxes on the property, period. That's it. So I mean, that's what was in my head.
and I'm just trying to find out why you made the decision.
I-
And
But-
I just told you.
I understand.
Stop, but that's like the Supreme Court. 5 of them say one thing, 4 of them say the other, and the 5 are gonna ask the 4 why they did what they did. 4 are gonna ask the 5 why they did what they did. You know what? Because they did. That was their decision. And maybe the 5 don't agree with the 4 don't agree with the 5.
Fair enough.
But so I don't know the point of this. Maybe you don't agree with this, maybe you do. Who cares?
I was just trying to understand why you made the decision you made. And
Yeah, well,
to
you
ask
know,
if,
that happens all the time in
And that's
court and
fine.
judges. You want to understand why people make decisions and, you
I
know, they
I-
made the decision. What are you gonna do?
nothing. I mean, at the end of the day,
Yeah.
BAs make decisions. And this was one where there was 3 properties and I wanted to understand if to what extent whether you believe the agreement applied to the properties,
I
and
think
that's
you
why you
said
made the
yes.
decision.
Did you say yes?
Of course.
Yes,
Okay,
okay.
there you go.
So we put in, and that's what we said our reason was.
Okay. I also wanted to give an opportunity to show you where I thought possibly the agreement may not have applied, so that you'd have an opportunity to respond. That's what I was trying to do.
Mhm.
And it could, and a response could have been, okay, well, I guess we didn't see that. That's what I was trying to, that's what I was trying to just ask.
Actually,
you
I
a question.
did see it
Okay,
and calculated all in my head and came up with, this is what I thought. And I explained it more to Lori and Donna, but taking all that into account, what you just said, I didn't, review this and spend hours on it, but I did look at it and I did see that. But I still came up with section 4 that said any property taxes. End of the case.
and by the way, just to be clear for the record, I haven't reached my own conclusion as to whether
Yeah.
it applies or not, because I think it's very confusing that you've got properties on the Schedule A.
Yeah.
That if they didn't apply, why do you have them on the Schedule A? And why not put them on a Schedule B?
Yeah.
So I haven't even figured out, I
And
have
also,
not.
why is the tax assessor also saying solar, solar, solar? I mean, so there was no question in his head, it was solar, no question in ours. And also remember the year before, when those board members got this tax stabilization agreement from Della, it was said, hands off, you can't make any change on these things. This is it, you're
So
stuck with it.
let's talk about that. So the year before, is it your understanding that the prior assessor informed the BAA that,
I think you gotta ask Donna or Lori that, because I
Okay.
wasn't there.
okay,
But that's where they got the tax stabilization agreement from, and that's what it was. Todd's statement here that he told us made it appear as though this tax first payment is due July 1st, 2022. In other words, tax stabilization agreement hasn't come in yet, doesn't apply. When we knew in it, it did apply from the preceding year.
and
So
again,
that's,
just so we're clear, I haven't finished my review of this and concluded one way or another whether I think it applies or not. It is confusing at the very least. I don't understand why if these other 3 properties that were the subject of appeals 307, 308, 309 that were filed on the 21 grand list, which you heard in 22, why they wouldn't have been on a separate schedule like a Schedule B, because I think it's confusing. I haven't
you
even
could ask the
finished.
town attorney that. That's more of a drafting problem for them and
I don't-
not making the rest of the people.
Again, I don't know. I haven't finished my work.
Yeah.
I haven't finished my review of it. So just so you know where I stand on it, that's why I'm asking you. Part of it is I'm trying to understand
Yeah.
where I may have looked at this quickly and I may be off. And I was kind of, and to be frank with you, I was looking for maybe for your insight as to something I may be missing.
I mean, I think to be really fair about
Yeah.
this, we would need to make a chart of every decision that was made. Go through each one, review it, decide whether there's any questions that there are about why it was decided that way, why are we just like picking certain ones? We should review each and every one.
Well, because, for example, I disagree with that for the simple reason that BA makes a decision, whether I think it's right or wrong is irrelevant, and I'm not gonna do that. I'm not gonna opine on all your decisions. It's not my place. It's not appropriate. Where you have an agreement, where you have decisions made on 3 commercial properties. And the BAA took the property, which were substantial values, and took it down to 0 because they believe a tax agreement applied. We should figure out whether in fact it does or doesn't, because then that would affect the assessor on the next grand list.
I agree, but I don't think this is the forum to figure that out because we don't have the statutes in front of us. We don't have the research.
Probably have
capabilities.
nutmeg in the town.
We don't have all the
figure it out now.
documents.
I'm gonna follow up with them,
Yeah.
and I
Yeah.
intend to do that.
Yeah.
Yeah.
The reason I was asking the question is to figure out what the BAA did, and secondly, maybe I missed something when I looked at it quickly and see if you had any different insight. You're an attorney, you're the chairman of BAA. That's the only reason I asked you. This isn't gotcha stuff. At the end of the day, maybe the BAA misinterpreted the agreement because it was confusing. So what? It happens. I don't know.
Right, yeah, what is the point of trying to prove that there were mistakes made in decisions by the BAA? What would be the point of that?
Well, I think it's not whether the BAA made a mistake. If the assessor on the next grand list, which I think he would overrule their decision for the next grand list, that may be wrong.
Mhm.
So, there's assessors, I'll just tell you, there's assessors who I've seen in other towns that have overruled BAA decisions. I felt they were wrong. The BAA was right. They ruled in my favor. This happened on the solar cases, I represent the Green Bank on the rooftop solar cases. And there was one town where each year the BAA would rule in my favor. And then the assessor, it wasn't Todd, or another assessor would overrule the next year. And I said, what are you doing? Like, the BAA made a decision. There's nothing's changed. Why are you overruling it each time? So to answer your question, but this review process is not intended to review and critique every decision made by the BAA. So those are the applications that I wanted to discuss with you. One more, Moose Lodge. Did the BAA reinstate the club's exemption?
Yes.
Okay. And are there, what was the reason for the BAA reinstating the club's exemption for the Moose Lodge?
Sure. The Moose Club initially complained to the town manager. And they provided the manager with 400 pages or so of documents, tax returns, and everything else show that they were entitled to it. And the town manager, according to Moose Club, told them, well, don't worry about it. She got it handled. They took an appeal anyway, came in, and there were no documents they had with them. They said, well, gee, we left them with the manager. Manager said she had given them to Todd. We asked Vicky for those documents so we could read them. Vicky, after being asked repeatedly for them, did bring them in one day when we were having hearings. But she would not let us read them or take them home or give us a copy. But she made Lori, so we took Lori off of hearings, put her on to read all of these 400 pages during the time. And then Lori summarized for us what it was, and you had to give those documents back because for whatever reason, they didn't want the board to have them. So on the basis of.
Can I stop you
Lori
right there so we don't,
reading it,
so I make sure Matt, I want to know, I want to know.
Lori will tell you the whole.
Okay,
thing.
but I want to know, just let's make a
Yeah.
note. If there were 400, however many
Yeah.
pages the
Yeah.
Moose Lodge gave to the
Yeah.
town. If they gave those documents to the town in
Mhm.
support of their appeal,
Mhm.
why was it not included with the appeal? Or if the
Mhm.
assessor's office had it, why did the assessor's office not give a copy to the BAA? Why would the assessor's office let the BAA review it and not have a copy?
And take it back right afterward. We had to review it. just that
I'm
time.
making a note for
Those
us.
are great things. That's.
I don't
yeah,
know, that doesn't make
Lori
sense.
is the one that reviewed it all and would understand a lot of the tax stuff.
I think I could just
Yeah.
probably rather ask the assessor why. It doesn't make sense to me, so.
Can
okay.
I, yeah, that's true. But that's Lori would be the one to verify what I just told you. But what I saw was she coming in with the documents, and then we had to take Lori up and have her go ahead and do that.
So the bottom line is that based on the review of what was it based on the review of that documentation that the BAA did?
And their testimony.
Okay, and what
Yeah,
was,
and-
what was their
Well,
testimony?
I don't remember the whole thing, but I just remember that what they testified to was that they were tax exempt, nonprofit, whatever the wording is. Again, Lori would know better, that whole thing.
Are there other moose lodges in Connecticut?
Oh, yeah.
There's one in Norwalk that I know
Yeah.
went out of it, that's no longer in
Yeah, no, this
business.
one's on South Road. See, I go by there all the time.
So there's others in
Yeah.
the state.
I believe so.
Do you know if any of those are tax exempt?
I think they're all tax exempt, but again, ask Lori.
There is some allegations, I think, made by the BAA and the reports that were issued regarding
I'm
sure.
gonna just interrupt for 1 moment again.
Yep.
Because I do have Donna on my mind. If you represent that you can finish her by 5 o'clock today, she can stay, but otherwise, we really need to let her go.
All
She's been waiting.
That's fair enough.
She's been waiting 4 hours now.
So why don't we just, you give me 5 minutes, I'm just gonna go quickly through these questions.
Okay.
Let's bring it
I
up.
don't want to rush you. We could have Donna come back another day.
I would say
It's not like I'm rushing you.
We could
Take
always,
as long as you want.
if we don't finish it, we could always finish her another day, but let's see how far we get with her.
Okay.
But I understand time, this is taking longer than we expected, so let me just quickly finish, I'm almost there. The BA had stated concerns about the assessor changing the data on the field cards. This was related to the effective year of building the Fountain of Youth Code. I think you earlier said I should ask the other BA members, okay,
Donna and Lori, both of whom
okay.
got copies and all that.
Just want to
stuff.
clarify that, okay. Lastly, the BA hiring its own attorney. Do you believe that the BA has the authority to be able to hire its own attorney?
Yeah, I think individually we can and collectively we can.
And when you say collectively, you mean the board has the right to hire counsel, okay? We're town, and I'm gonna ask your attorney, if there's any questions I ask that are of concern, you let me know, okay? So far, have any town funds been used to pay Ms. Baird's legal bills? Or if she, okay,
We haven't gotten anything from the town. We
okay,
haven't asked for anything from the town yet.
okay. At some point, does the BAA plan on submitting bills for Ms. Baird to be paid for by the town?
Well, I can't speak for the whole board because we haven't had a meeting on that to determine it, but we'll see when the time comes that the payment is not ripe for discussion now, I don't believe. We hired our own attorney because the town attorney was completely hostile to us and was conflicted with his representation actively of the town assessor against us, as well as the town manager and administration. So his legal opinion that we never asked for wasn't advisory, that was directory without our input. And I already covered all of that, so I don't need to go through that again. But we felt as though we needed an independent attorney to give us sound advice.
With regard to records, at some point with regard to the 22, with regard to the appeals of the 21 grant list, which took place in the spring of 22. Did the BAA hold those records somewhere other than in town hall?
Yes,
And where were the records held?
well, they're either with Lori Longi, the recording secretary, or they're with Donna, who was if Lori wasn't around.
So,
This is consistent with the way Donna was doing it for the last 9 years.
okay, so in the past, was she holding the actual records at her home?
I believe so. Now, when you say records too, anything that's an original that came from the Board of Assessment, from the town assessor, those went back to them. They were back to them as soon as we made our decision. So whatever they gave us, its originals, we don't have any of their originals. From in terms of our backup materials for how we made our decisions and all of that, those we kept and then turned over when the final hearings were done in of September with all the autos. And part of the reasons that we did that was that you see. Well, here it is. Part of the reason that we did it is that we were really concerned about Todd's statement that he's doesn't keep track of records too good. We didn't want the records to get lost. That's before the hearing started. And then after we had made our decisions and all of that in the first part of the hearings, then we heard from Attorney Talberg that wanted us to turn over all the assessor's records, which he already had, and our records, including copies or anything that we made, so that basically we would have nothing to back up our decisions before we're even done with everything. Then as time went on, let's see. Yeah, the original documents I gave to Vicky Rose on May 25th, 2022, May 31st, 2022. We didn't retain any of those originals. And then for classification of photocopies of assessor's records, Lori and Donna would from time to time hear from people who wanted a copy of their records. So they would make them a copy. Lori, as recording secretary, would certify they were true and correct from our records and give them their copies. So nobody from the town, a town employee or town agent, had called looking for, I need a copy of this or a copy of that. And finally, because we were concerned about the integrity of those records, as more time went on and allegations were surfacing from the assessor's office about us doing this, that, or the other thing wrong, then we became even more concerned about preserving the integrity. Finally had a meeting to decide what to do with them. And then we decided to follow the statute that we were familiar with in terms of turning them all over to the town clerk. And then once we did that, then that's that. So the town clerk has them. And then they somehow got to you, whether they came from somebody else, I don't know. All I know is we maintain our files. And as somewhat proof of that, that's happened in the past, I got a, I don't know if you have the email from Ellen, where she sent in July, somebody had filed an appeal with them, with her, and she said, well, I'm forwarding this to, for your files. So, I mean, this is not unusual that we would keep our own records, other than when you're all done with the stuff, then they were properly filed with the town clerk.
Going forward, we have the appeals coming up
Yeah.
in this spring.
Yeah.
For those appeals of the 22 grand list,
Yeah.
will the BAA maintain all the records associated with the BAA appeals in town hall, either in the clerk's office or in the assessor's office?
Clerk's office, we would. Assessor's office, we don't trust them.
So
We would be happy to do that. Actually, that would be wonderful. We tried doing stuff with the clerk, but the clerk was on orders from higher up to shift it all to the town tax assessor. But if we could do that, Mario, would make all our lives easier. We don't like traipsing around with all this stuff or being responsible for it.
and I don't think you should.
Yeah.
So why don't we, so just for the record.
Yeah.
Is it your position as chairman that the record should be maintained in town hall, that you have concerns about those records being maintained by the assessor's office?
Yeah.
And your suggestion would be for those records to be maintained by the clerk's office. Is that correct?
We have absolute confidence in the clerk. Yes. Actually, what you just said is, yeah, good.
I
I'd
don't,
have to bounce it off the other two, but I can't believe.
I just asked
you.
your,
Like me. Yeah, mine,
just asked
that's my
your
opinion.
all right, I don't have anything further. Rachel's,
I just want to ask about those bait stamp pages right here, if you could pull
Yes.
those. Tom, did you say that except for pages 1 and 2, which is 5988 to 5989,
Yeah.
the other things, the other documents, 5990 through, I'm making a record,
Yeah.
6001, you had at the time of the hearing?
What we made at the time of the hearing.
Yeah,
In our decision, because this was made at the hearing, and then this was made for our decision, so. Yeah, but when the hearing was done, we had all of these. Yeah, what he first gave me was the first 2 pages. And then we had the deed from April.
no, I was just wondering, and I don't know if you know the answer to this question, but if you look at 5996, I think.
Mhm.
It's an email dated April 21st. Oh, it's from
2021.
2021.
You know what? Yeah, that's,
Solve the problem.
that's
Okay.
how they became aware that there
Okay.
was a problem here.
Mhm.
And that's consistent, by the way,
Yeah.
with the
Got it.
memo that he submitted.
Yeah,
Okay.
He said
that's it.
he retained
Yeah.
counsel, and I think in the
Yeah.
spring of 21.
Yeah,
that makes sense.
So it's consistent. Okay, I don't have anything further.
Do you want me to send you that email that Ellen gave me? Is that important or not?
I think I have it already.
Okay, the
but-
one that she sent me in July saying for your records, keep this, and she sends it to my office.
I'm pretty confident anything that,
Because Talbot kept telling everybody, I gotta get my mail at the tax assessors.
but if I could just, want to make sure before we're done. I want to ask you or Rachel, either of you have anything else you want to, add before we're done?
I do.
not that I can think of right
Okay.
now.
All right.
I had a few, but I just want to give you one.
If you think
Oh,
of something
sorry,
later, I
Anthony.
could put you back on Zoom at some
Oh, yeah,
point
no,
at a
oh,
later
I'm
date if
sorry.
you needed me to.
Well,
Yeah, you did have a couple things actually.
All right, what do you
that
got?
You had mentioned to me.
yeah,
You need a break for a minute?
no,
Okay,
You had mentioned that. I know that was.
that's the one I want to tell them about.
Okay.
okay,
yeah.
so what is it?
Okay, this is, well, first of all, you're familiar with Romano, the Romano appeal.
Yes. I-
Okay,
that's
so
why
you're
I-
familiar with that. We don't have to go through that.
Please no.
And that one, he then rescinded, and so now the guy's got all of his, he's back at 490, everything's all set. Okay, so now, the other one that we haven't talked about is the Alimo family. And what had happened with the Alimo family is,
Who was representing the Limo family?
nobody at this point.
Okay.
It was, well, nobody at this point, at this juncture. she
At
got a
some
lawyer
point,
now.
did somebody represent him?
I believe Carl Andolina at the
The
end.
only reason I ask is because I
Yeah.
thought you suggested I interview Carl Angelino.
Oh, yeah.
So then.
Well, not necessarily for what I'm gonna tell you.
Okay,
This is,
To
I'm not
kind
gonna
of
tell you
avoid
substance
repetition,
of-
okay.
no. So here's what happens is, I'm gonna give you this whole package, but I'm just gonna go through it quickly to tell. Because it's got a little different twist.
All right, yeah, just give us the quick highlight,
Yeah.
like it's done.
December 31st, the Alimos send back or the Alimos are informed that the assessor said he's withdrawing their forest classification because they needed an update certificate. So he sends them that December 31st. And the Alimo family that gets it, they, couple of them were sick, so they didn't respond right away. Subsequently, they do respond and they send a letter. And they send me a copy. Okay, so I'm gonna give you a copy of the envelope I got from the Alimos. And the letter is to the town assessor, basically saying, you know, we don't understand why we have to do this and so on. And also saying nobody was here to get the mail when it came in. My sister's had serious operation and so on and so forth. So that goes to the town assessor with a copy to the Board of Assessment Appeals chairman, which is me. And I get it. This is the envelope. I got the real envelope here, which I've never opened because I was too busy at the time. And anyway, it contains that letter that I got from Vicky Rose. Then, when they don't get anything back from the tax assessor on May 9th, they send another letter to the assessor saying, hey, listen, I've been trying to call you. You don't return my calls. I don't understand what's happened, but we think we shouldn't have to go through this forest certificate. And they again send a copy of that letter to me. I got the envelope, didn't open it, still got the stuff in it. So then the next thing that happens is on June the 10th, the applicant sends this letter. But I want you to read it because it's to me, care of the tax assessor. And it has their appeal with it. Okay, and there's the appeal form. Okay, so
It looks
that's,
like the appeal was not received until June of
yeah,
22.
that's not even the issue. Issue is that letter is addressed to me, Chairman, Board of Assessment Appeals.
Yes.
There's no CC to the assessor. What the assessor did is he confiscated that envelope, opened it up, and then responded to it, but never gave it to me or told me about it.
Okay.
We're not done yet. So then what happens is then the assessor sends this to the appellant.
By the way, you're gonna give me a copy of this, right?
I'm going to cover everything I just told you.
Okay, okay. keep going.
Okay, sends this to the appellant basically,
When you say this, you're referring to a letter
Yeah.
dated June 20th, just for the transcript, June 20, just for the tape, June 20th, 2022, which is a letter from Vicky Rose to Esther Alimo and Charles Alimo.
Mhm.
And it says the assessor's office is in receipt of your assessment appeal form for 35 Weymouth Road. Our office received the form on June 13, 2022. Pursuant to state statutes, it wasn't timely received. The BA is already met. The next time you file an appeal is with deadline of February 20, 2023.
correct. So now, again, the way this is written, and then he sent me a copy of it, which I got. And I then called Vicky and I said, Vicky, this is a little weird. I said, how come I didn't get a copy of the letter from June 13th? And then she said, well, Todd told her to open the mail and he's gonna handle it. So then he handles it and says the assessor's office is in receipt. He doesn't say, oh, by the way, Tyler shipped this to us or anything of that nature. So I then asked her to print out a copy of her file, which I got. And then, so I'm putting that all together and giving you back this. And what I'm trying to make some sense of for you is that my mail was intercepted by this guy. He then made decisions on it and then had her sign the letter back to the appellant to make it appear as though this is all legitimate and we must have got it and turned it over to him to do. I thought it was deceptive, deceiving, deceitful, and I printed this out way back when, that I think it's a federal violation of the mail go. Now, I'm not telling you this.
Hang on, just for the record, I want to make sure. So when you say
Yeah.
you handed me a document, you just handed me a document that says US code, 18 US code 1702 obstruction of correspondence. And then after that, you have all the, all right.
Yeah,
So what you just
everything
handed,
I just talked
so what you're referring to was the federal code, the provision of the federal code that you believe could have been violated by the assessor here. Is that accurate?
by what they say is obstruction of correspondence when he took a letter that he knows.
I get it. I understand.
Okay,
And-
well, I know, but I want to put it on here.
Okay, yeah.
Okay, so he took a letter addressed to me. They know where I am. They gave me all my prior mail. Yet he kept this one and then turned around and usurped the board's authority in terms of even responding to it. I'm not disagreeing with this response. I'm just saying he shouldn't have done that. And then he sends it off to the people and sends me a copy as though completely ignoring the letter that I still never got. So he opened my mail. He then either destroyed it or put it someplace, but I still haven't gotten it from him. And at the time, I thought over what to do and decided to do nothing right now, because when it happened, you were just coming into the picture and I said, you know what, we'll wait for this. Because he also, usually when he was doing something untoward, as he did in the beginning of our discussions, he would have Vicky do the email to me, or Vicky sign a letter, or Vicky do this, that, and the other thing. But I really resent it when somebody takes my mail, usurps my authority, sends out something pretending that the board said, okay. It's just wrong. Now, I do know that after this, I brought this up to our board because we had another meeting after our stuff. We say, you know, what's our authority at meetings? Well, every now and then we do. So with that particular meeting, I got authority from the board to contact the appellant to see what happened with everything. The appellant asked me for names of attorneys that represent people and stuff, and I gave him 3 names. And of the 3 names, he went to Carl Andolina, and what I understand now is that then their forestry status has been restored. So,
Okay.
but I'm sure you wouldn't get any of that information from the town, but I figured you should know it.
I don't disagree. It's helpful to know. Thank you. Is there anything else you want to share with me?
Not right now. I got other stuff, but I think see if you can finish up, Donna.
Thank
And
you.
if there's something that important, I'll get a hold of Rachel or we can do something else.
That's fine.
But the majority of the stuff has been covered, and you were thorough and I was probably too thorough, but anyway.
Thank you. I'm
Sorry
gonna
to
cut the
take up
tape.
so much time.
It's okay. Take whatever time you need. I'm gonna shut off tape now. Is that okay?
Yes.
All right. Thank you.
Did I give you a copy of the Limo stuff?
Yeah,
Okay, you got it.
yeah.